Item 20 of supplementary list for judgment.
I'm just reading the email. From an analysis of the evidence available on record in its entirety, we have the opinion that the prosecution has been able to establish the guilt of accused appellant beyond reasonable doubt based on circumstantial evidence. In view of the above, conviction of the appellant under Section 302 IPC and sentence of life imprisonment by the trial court by judgment and order dated 27/6/2019 is affirmed. In the result, appeal is dismissed.
Obliged.
Obliged. Mentions may be made.
May I please, Your Lordship? Victim is the item. May I please, Your Lordship? My victim is the item number 9, my lord. Can this matter be adjourned for today, my lord? Can it be taken on 6 or 7, my lord? Deborah, my lord.
Deborah,
Yes, my lord.
item 8.
Item 9, my lord.
Oh, item 9.
Yes, my lord.
No mention slip.
No, my lord.
Why-
Sorry,
why-
sorry, my lord. Mr. H. Chaudhary, he is unable to come to the court, my lord. That's why, my lord. Can be on 6 or 7, my lord.
On request made by Deborah, the counsel for the applicant. This matter after 1 week.
My lord, can be on 7th, my
No
lord.
date.
Kindly, my lord.
You
7th.
have not given your mention slip. We are
Sorry,
not
my lord.
fixing date.
Sorry, my lord. He was unable to come to the court, ma'am.
After 1 week.
Obliged, ma'am.
May I please, Your Lordship? We to concern of the other side, I beg to mention item number 8, my lord.
Yes.
Matter may be taken after 4 weeks, my lord. Okay,
Yes.
they have problem, Lordship.
Okay. UMS,
And Bora,
you are appearing on behalf of
F count,
S count
my lord.
on request made on behalf of LSS count and the council for the applicant. Is the matter
After 4 weeks, my lord.
after 4 weeks.
Obliged, ma'am.
May I please, Your Lordship?
Hmm.
I would like to mention item number 19. Your Honor.
Yes.
How could the appellant, Your Lordship? I would like to mention item number 19.
Yes, please.
Say about it. Okay, it's a matrimonial suit. Matter may be fixed before a mediator, Your Lordship.
Your Lordship, I am for the respondent. Your Lordship, both the parties would like to refer the matter before the mediation center. High Court Mediation Center, if the Honorable Court please to direct both the parties to refer the matter to the mediation, it will be highly obliged, Your Lordship.
Okay. Learned counsel for the parties submits that the parties would like to appear before the mediation center of the Guwahati High Court. Stop. Accordingly, parties are directed to appear before the mediation center of the Guwahati High Court. You want the date fixed
Yes, Your Lordship.
on today is
Second.
19 June
Yes, Your
on
Lordship.
19th.
Deeply obliged.
Obliged.
Thereafter, the mediation center shall furnish a report.
Deeply obliged.
Item 1 of daily list. Motion.
Just registry is also directed to open the meeting.
May I please, Your Lordship?
Yes.
The petitioners repeated Lordship are all ex-casual labor under the railway department, Lordship. And their names appear in the live register of casual worker register maintained by the railway authorities. Lordship. In the year 1998, Lordship, a special drive was conducted to absorb all the casual laborers in the regular grade D post. Lordship. And some similarly situated candidate has already been absorbed, but leaving the candidates and other petitioners and other candidates. Lordship. Thereafter, they have approached the Central Administrative Tribunal by filing various original applications, and by common order dated 14/6/2007, the tribunal has directed the respondent authorities to constitute a high-level committee of higher officers to consider the case of the petitioners and other similarly situated candidates, and if required, give personal hearing to them, and then directed to complete the exercise within 4 months. Against that order, the respondent authorities has come to the Honorable High Court challenging the order dated to 14/6/2007.
That was dismissed.
That was also dismissed, upholding the order of the tribunal and directing the respondent to comply with the order. That order was not complied till today, Lordship. In the meantime, the petitioners again filed some original application before the Central Administrative Tribunal, and similar order was passed, but till date.
Where?
My lord, this writ petition is preferred against the order passed by the Central Administrative Tribunal. My lord, we'll see the prayer portion. My lord, the prayer portion rather reflects, my lord, it is a kind of a new prayer, my lord, which is made in a writ petition. There is no mention against which order the challenge is made. My lord, it is a prayer for a direction to make rule absolute by directing
Where is the order of the tribunal?
which order is challenging.
The tribunal order, Lordship, at page 68. And opposite part at page 84.
My lord, this is 2007 order where
Yeah.
petitioners are not a party. Against which order they have.
Which order are you challenging in this writ petition?
Because I have been here for only a direction to comply with that order, Lordship.
Which order?
Order dated 14/6/2007, Lordship.
2007, they are not the petitioners, my lord.
You withdraw and file afresh. Better.
My lord,
This is very vague. You withdraw and file afresh. I'll give you liberty to file afresh.
But
You are Mr.
M. Rana.
Mr. M. Rana, Learned Counsel for the petitioner. Press for withdrawal of this writ petition with liberty to file afresh. Mr. H. Gupta, isn't that
my lord.
Learned? You are deputy SGI?
My lord, CGC.
Learned CGC
Sanjeev,
appears for all the respondents.
the respondent.
All the respondents, writ petition is accordingly dismissed on withdrawal with liberty as per.
Obliged.
Yeah.
2 and 3 admission.
Public. Lordship, item 2 and 3, Lordship, I am seeking some accommodation, Lordship. Actually, that escaped my notice, Lordship. If it can be on Monday, Lordship, I will. Connected matters from the postal department, Lordship.
On request made by RKD Chowdhury, Learned Deputy SGI. This matter. Monday will be difficult. I think.
Any day, Lordship. Otherwise, I am ready, Lordship.
Or we'll say after a week.
Lordship.
After a week. Both the matters.
Yes, both are connected matters.
Or
For I am appearing for the respondent Brahmaputra Golden, the Union of India Worship. Mr. UK Nair appears for the petitioner. This is a case where lordship, so petitioners are seeking for the scheme of pension. They had opted for CPF. But that scheme was lordship bound by some date. After that, they had made some application which was again not considered by the government. And the learned CAT had rejected their claims. Against that, they have filed an appeal by way of this writ petition lordship.
Then nobody is present.
Lordship may post it after 1 week, lordship.
None appears for the petitioner. Mr. RPD Chowdhury, the deputy STA, appears for the respondents. This the matter after 2 weeks.
File.
Five, it's a jail appeal
Jail
coming
appeal.
up, yes, for the first time. Amicus curiae needs to be appointed.
This is an appeal from jail. Stop. Admit. Call for the LCRs. MSS Jahan, and additional PP appears for the state of Assam. Registry is directed to appoint an amicus curiae from the independent list. And this the matter after 4 weeks.
6,
6, Mr. Joshua Das was not very well. I've apprised your lordship on the other occasion.
I'm appearing on the behalf of the legal aid council, your lordship.
He is there.
Is a criminal appeal, your lordship, against the judgment passed by the London Edition Session Judge Golaghat, your lordship, convicting the appellant for to undergo life imprisonment, to submit a fine, your lordship.
It's not a jail appeal, is it?
No,
He's inside
yes,
jail, your
yes, it's a jail
Is
appeal.
it a jail appeal?
Yes, your lordship.
He's the legal aid
You are
counsel.
He's a, Mr. Jadar is the legal aid counsel, your lordship. He's unable to speak because he underwent an operation, your lordship. So I'm appearing on his behalf.
First, Mr.
A Das, your lordship,
A Das.
on behalf of Mr. J. Das,
Counsel
your lordship,
appearing on behalf of Mr. J. Das.
the legal aid counsel.
For the appellant. Admit. Call for LCR. Ms. L. Jahan, and the additional PP appears for respond number 1. Here, registry will have to take steps, isn't
Yes,
it?
yes.
Registry is directed to take steps for service of notice on the respond number 2 by registered post AD within 1 week from today. List after 4 weeks.
Oblige, your lordship.
7,
7 is statutory appeal under section
May please, your lordship.
302.
Lordship, the appeal is against the judgment and order that lordship,
Your
third,
name?
J. Hatimuriya, lordship,
J.
Hatimuriya.
Third, Mr. J. Hatimuriya, learned counsel for the appellant. Admit call for LCS, MSS Jahan, learned additional PP. Appears on behalf of
Respond number 1.
who is your appeal memo?
174.
Respond number 1. Stop. Appellant to take steps for service of notice on respond number 2 by registered post ID within 1 week from today. List after 4 weeks.
Oblige.
10, order.
Then to. Gopal, please. Oh, you can do. Oh, you're for respondent. It's a jail appeal again. Mr. Mondal is there. Respondent side appears.
LCS have come.
Yes, LCR is here.
Prepare the paper book.
That's it.
None appears for the appellant.
May I please, your lordship? Like only the documents have to be furnished to us. We have not been given any document except the issue of notice.
That's
When
why
after the paper book is
after
prepared.
paper book, you'll
you'll
get
get
your
it.
Paper
paper
book
book.
has not been furnished to
No,
us.
it's not prepared.
We are preparing the paper book now only.
Okay,
Paper book prepared.
MS.
much of this.
Non-episode MS is done, then it addition. Applies for respondent number 1, isn't it?
Yes. I'm
And
first.
Mr.
S Sood on behalf of MU Mahmood.
S. Sood,
Sood, SU1,
learned counsel. Appearing on behalf of
MU Mahmood.
MU Mahmood.
His name is also there in the Wakalat.
Appears, okay, S. Sood, learned counsel appears for the respondent number 2. Concerns have been received. Registry is directed to prepare the paper book and list the matter after 6 weeks.
6. Paper book not time.
Okay.
11,
Mr. Hassan is otherwise regular today again. Last occasion also he was not here. Maybe something has happened. I'll call him up. Otherwise LCR is here.
Okay. Amicus curiae is absent. MSS done and additional FTP appears for the state of Assam. This is a jail appeal.
Yes.
LCRs have been
amicus.
received. Registry is directed to prepare the paper book and list the matter after 6 weeks.
It will repeat it for-
12,
We have final
Thank you, Lord.
objection.
Kindly pass over the matter for timing. My senior is at the other phone.
Yes, Bhuyan, what,
Wash after some time.
We have final objection, your lordship.
you file your objection?
Yes. It's on record, manner. After some time. then.
13, 13 and 14,
I filed my objection in respect of Ram Naresh
I am
Rawat.
the amicus,
It's on
madam.
record.
I'm appearing for Mr. Sri Ram Naresh Chauhan, madam. The prayer for bail has been filed, madam, on the ground that he is a 90-year-old man now, madam. At the time of the judgment, he was 85 years old. Now he is 90, my lord. He is suffering from various illness. So on that ground, my lord,
What illness?
your lordship comes to page 4 of my application, my lord. Page 4, para 3, my lord. At the time of passing of the judgment, he was 85.
That is all right.
Paragraph 4, my lord. He felt dizzy and he was taken to the hospital, my lord. Respectfully, I submit, my lord, at the age of 90, my lord, he is not a threat to the society. And there is no chance of him fleeing, my lord, or running away. Your lordship may kindly consider.
And Jahan,
Lordship, yes, as far as the marriage is concerned, while it is in the evidence that while her husband was coming from the market, in the market itself, he was assaulted by 2 other persons, one who absconded and one who died. As far as the applicant is concerned, she said that after the deceased reached home and he asked for a glass of water, when she brought that glass of water from inside, she saw applicant again assaulted.
PW1.
Yes, PW, the informant, yes, PW1,
PW1,
the
right.
wife of the deceased. As far as married, the first assault was not by him, but second, he assaulted, he was there. So 90 years, of course, that is not in dispute. He is 90 years, he is behind the bar. And leave it to your lordship, lordship can, and other evidence also, I have seen, PW7 is also an eyewitness. He said that 5 accused persons came to the house of the deceased and assaulted him. And then there was an earlier fight also. He did not speak about the applicant, 7. And another, again, 8 is also an eyewitness. 8 said that accused person came to the house of the victim and assaulted him with a machete. She also stated that victim shouted for help and she sent her son to look into the matter, and that she too followed and saw one accused person. Again, she did not.
We will not enter into the minutes. Considering his age,
Lordship. And why I'm saying about the marriage, even the marriage says that he was not the main assailant. The main assailant, one died and one absconded. So I'll not object, Lordship can give. And let the appeal be heard soon.
we'll hear the explanation.
Lordship.
Yeah, Mr.
And Decca, my lord.
For the applicant.
For that.
Not Mr. N. Decker, Leonard. You amicus curiae.
Amicus.
Amicus curiae. For the applicant. Also heard MSS Jahan and additional people as. Stop.
Only Ram Naresh Chauhan. There are other appellants.
This is an application. How many applicants are here?
Only one, my lord.
No, in the appeal, there are others.
In the appeal also, this is a jail appeal, my lord. There is a connected appeal, item number 14. My learned friend appears, my lord.
I'm in 14.
Lakshman Chauhan.
Lakshman Chauhan.
This is an application. Under section 389 within bracket 2 of the Code of Criminal Procedure 1973. Praying for suspension of the conviction and sentence passed on 21/12/2018 by the Learned Sessions Judge Karbi Anglong in Sessions case number 32/1998 in respect of the present applicant, namely Shri
Ram Naresh Chauhan.
Ram Naresh Chauhan. Stop. It is the case of the applicant that when the judgment was passed on 21/12/2018, he was 85 years age, 85 years old, and presently he's around 90 years of age, and he has health issues while staying in the jail. Stop. It is also submitted that the applicant had to be admitted to the jail hospital as he was feeling dizzy and he was unable to go about his day-to-day activities. Stop. But on perusal of records, we find that the applicant is not the main assailant. However, without entering into merits at this stage, and considering that the applicant is about 90 years old, we accordingly grant bail to the applicant, namely Shri Ram Naresh Chauhan, till the disposal of the connected criminal appeal. I is accordingly allowed. In the main criminal appeal, heard Mr. N. Decker.
In item.
You are in the criminal appeal also? No.
Yes, my lord.
I'm in the criminal appeal of.
No, both. There are two criminal appeals, my lord.
Hmm.
One is 296, where my learned friend appears, and 48, my lord, I appear as the amicus.
You are appearing in?
Item number 13, criminal appeal 48, my lord.
Heard N. Decker and counsel for the applicant, for the appellant in criminal appeal jail 48/2019. Also heard Mr.
DK Bhattacharya. in
D.K.
item number-
Bhattacharya, learned counsel for the appellant in criminal appeal 296/2019.
If I may submit, my lord, this paper book is ready. It can come up for hearing after the summer vacations.
Okay.
Item 19 matter.
Also heard as Jahan. Then the additional
Yes.
yes. Paper book is ready.
Paper book
Yes,
is ready,
it's
ma'am.
ready.
Paper book is ready. Accordingly, list these appeals for hearing after the summer vacation.
Oblige.
Next. Yes, ma'am.
15.
My lord, this is the application, bail application that we filed. The person is have serious hypertensive issues of Morigaon jail. Report was called for.
The report, I've just got it 5 minutes back. And the report says I couldn't make a copy out of it. It's in original. So the jailer writes on the basis, they don't know, the health officer writes that he is suffering from high blood pressure, continued headache left side, migraine, mild chest pain, and both knee joint pain. He has been referred to as MCH, Medical College Hospital, and GMCH, Guwahati, for proper Morigaon Civil Hospital and CMCH for proper diagnosis and better treatment. He has been undergoing treatment under our supervision, advice of GMCH doctors and advice of GMCH doctors. His blood pressure is being regularly monitored at jail hospital. At present, he is not doing well. This is what. Lordship can also keep that in record. He has so many ailments, and last line that he writes is not doing very well. But
That is
then
why
he is
only
under
this, my lord.
treatment. Regular supervision. This is handwritten. He has just sent me.
But that is my only case. He's not keeping well. That is what I also been informed by my client. And his blood pressure, as per the last report that I have annexed at page 80 of my IA, it shows 210 by 120 BP. It is by Morigaon Civil Hospital, this document.
That is my normal pressure.
210, my lord, it's a hypertensive crisis. After 180 is hypertensive crisis. Anybody after 180 should be under constant treatment. He's on the verge of having a heart attack or a stroke.
That's why I'm saying that's my normal pressure. I'm having the 210 by 120.
Plus, my lord
He's
is,
scaring everyone, including your lordship.
he does not get proper treatment in jail. Your lordship will get that. He won't get that in jail. That is my only case, my lord, just because of his health ground.
I don't mind.
Yes, John.
Otherwise, I think merit-wise, I filed my objection. I think it's on record. But as far as health, leave it to him. He
And
can
if-
go for interim bail for some period, let him get
That's
treated
what
and then
we're thinking.
come back.
Maybe 2 months.
Hmm.
Until then.
Otherwise, he is under regular treatment. That is there. Sir.
Mr.
DK Bhattacharya.
But Mr. D.K. Bhattacharya is responsible for that. Also heard MSS John validation. Strong. By this application under section 389 within bracket 2 of the Code of Criminal Procedure 1973, the applicant, namely
Rajeshwar Bordoloi.
Rajeshwar Bordoloi, is praying for bail on the ground that the applicant is suffering from high blood pressure, continuous headache of the left side, migraine, and other related problems. But the applicant. Where's the sentence?
My lord, the sentence
Was
for
convicted.
life. Is convicted for life, 302
and
for life sentence and payment of 50,000.
Sentence to undergo
Page 2, I have mentioned it in the cost item. Page 2.
rigorous imprisonment for life under section 302 IPC, along with fine of rupees 50,000. And in default, a further period of 1 year of simple imprisonment. Stop. Para. No. By the judgment dated,
2622.
is it 2/6?
2622 and sentence dated 8/6/22.
By the judgment dated 2/6/2022 and sentence dated 8/6/2022, passed by the learned Sessions Judge Morigao in the Sessions case number 24/2015. Stop. Para. Considering the health condition of the applicant, this court directed the learned additional PP Assam to produce an updated medical report in respect of the applicant. Stop. Para. Today, when the matter is called up, learned additional PP has furnished a medical report issued by the medical and health officer, District Jail, Morigao, dated 31st May 2023, stating that the accused, namely Brajeshwar Bodole, is suffering from high blood pressure. What is this? Continued
Headache, I guess.
Headache. Continuous.
continuous headache of the left side, migraine, mild chest pain, and both knee joint pains. Stop. The applicant was referred to the MCH and the GMCH Guwahati for proper diagnosis and better treatment. Stop. The applicant is presently undergoing treatment under the supervision of the jail doctor. On the advice of the GMC doctors. And his blood pressure is being regularly monitored at the jail hospital. Stop. However, at present, he is not doing well. Stop. Therefore, accordingly, considering the health condition of the applicant, we grant interim bail of 2 months with effect from the date of release of the applicant from the, which jail was it?
Morigao
Morigao
District.
District.
From the Morigao District Jail. Stop. It is directed that the applicant shall surrender before the jail authorities immediately on expiry of 2 months. Stop. IA is accordingly allowed. This will keep it on record.
Not your case.
The jail, the medical report dated 31/5/2023 is placed on record.
Published.
What about the criminal appeal?
The criminal appeal, my lord, I guess there's a direction for production of the paper book.
Not yet done.
Not yet done.
Heard Mr. D.K. Bhattacharya, legal counsel for the applicant. Stop. For the applicant. Also heard MS.S. Jahan, in addition to PSR. Registry is reminded to prepare the paper book and release the matter after 3 weeks.
Not. There are 5 appellants, 5 appellants, yes.
Five.
The I is only for Brajeshwar.
Yeah,
Yes.
that's why we have mentioned his name on.
Sometimes it happens, you get confused. Lordship.
Published.
16.
Lordship, I apologize, Lordship. We missed our matter, item number 4.
Wait for your turn.
Uh.
Wait for your turn.
Si-
16.
16, Lordship, it's a petition praying for condonation of.
How many days delay?
My lord,
53 days.
it's an IA
I'm
for
not-
condonation of 30 days, my lord.
30 days you have.
I'm not objecting, Lordship. Condonation petition may be allowed and the main appeal may be.
Heard Mr. S.R. Rabba.
Yes, sir.
Learned counsel for the applicant. Stop by this applicant, also heard Mr. R.K. Chaudhary, learned DVG SGI on behalf of
NIA.
NIA. Stop. By this application, the applicant is praying for continuation of 30 days delay in filing the connected criminal appeal. Stop. We have perused the course shown in the present application. And we are also and we are satisfied. Stop. Mr. R. Chaudhary, learned deputy SGA has also no objections. Accordingly, the delay of 30 days in filing the connected criminal appeal is condoned. IS accordingly disposed of. Registrar is directed to register the criminal appeal in its matter in its usual course.
Obliged, my lord.
17.
Delay application.
May I please, your lordship? Lordship, there is an delay, I, your lordship, for delay.
How many
And then
days?
4 days, your lordship.
No, heard Mr.
S. Paul, your lordship.
S. Paul.
Paul, Paul.
Paul. Learned counsel for the applicant. Also heard MSS Jahan, learned additional PP. Assam. Stop. By this application, applicant is praying for continuation of 4 days delay in filing the connected criminal. This is a revision petition.
Appeal, your lordship.
Appeal.
You have mentioned criminal revision petition.
Yeah. In my copy, this is appeal only. Okay. How this one?
Page 2.
Page 2.
Oh, yes, sir.
Page 2, sir.
Sorry.
Clerical mistake. Key one.
In filing the connected criminal appeal. Stop. Para, we have perused the course shown in the present application and we are satisfied. MSS Jahan and the additional BP has also not been. Accordingly, the delay of 4 days in filing the connected criminal appeal is condoned. I is disposed of. Registry is directed to register the criminal appeal and makes the mapping of the victims. Oh, 1 minute. There's another IA.
Yes, your lordship, that is for bail, your lordship.
69.
And there is a
This will
criminal
come after registration of the appeal.
after receipt of the LCR, your lordship. Obliged.
Item 26, 27.
26 and 27, your lordship was pleased to fix them at reserve for judgment, my lord. We have discovered another appeal is pending. Criminal appeal jail 3460/2020.
3, 4.
Lordship, it would be 16/2020. Wherein my learned friend appears, your lordship. But it's not listed today. Other one.
It is
has
not
been-
listed today, lordship. Actually, what has happened in that matter, I think my name is shown the other time, but I missed out. Then I haven't received the paperwork as yet.
Paper book is ready here in criminal in 16,
Lordship,
16 of 2020. What
16,
is
my
the
lord.
status now?
I have not received the paper book from the status report, Lordship. Case status I have come to know. This appeal is pending. It's in the stage of admission, my lord.
You're not aware where the paper book is?
No, I have, I mean, last time when the matter was listed,
Criminal appeal,
I must have missed out, your lordship.
Judge. Right.
And I got to know there's a similar appeals are also there.
Lordship, it was last listed on 26/6/2020. It came out for admission. Saboniki. 26/6/2020. Right?
Where's Mr. Talukdar? Mr. A. Tiwari?
Mr. Atul Choudhury.
Lordship, kindly pass over the matter.
Why?
My senior is in another court.
What date is this? Date? Oh, this one, 26/6. No, we will list it along with it, but the problem is they are not here. Mr. Tiwari also is not there.
Today's day, I informed him in the morning, Manu. I informed him in the court.
We have no option but to release it from CAB
Heard.
Yeah.
Yeah, from CAB.
and then get it listed along with this.
Yes.
Yes, lordship. This matter has to be heard again. I mean, like if
Yeah. We'll have to
one
get-
person is not heard, then it will be. It should have been heard together, actually, like it's missed out. So,
But where's Talukdar and Tiwari? This order has to be passed in their presence.
Lordship, then after some time. Maybe.
Shall we take up after some time? Mr. Talukdar? After some time. After some.
18 of daily list.
Bhuyan, can you just send a message
Yes, I have already sent.
on the parties?
Yes. Lordship, 18, we have prepared the written submission. Lordship,
so I'm submitting those written arguments.
Item?
18, your Lordship,
18,
your Lordship
Lordship.
has heard the matter.
Oh.
Right.
The matter is already heard, only, I mean, I had to submit this,
Am I written?
so I have
Lordship,
submitted.
I have also prepared one.
Heard Kalita and Amicus Curiae. Also heard MS B. Bhuyan, learned the addition PBS song. Hearing concluded, just one example.
Lordship.
Lordship, one more matter. Your Lordship was pleased to fix it for today for submission of written argument. Criminal appeal 60J. It's not on board, my lord. May I submit the written argument, your Lordship? Written submission?
Yes, after. Let's go some.
It's not on list, in the list, my lord.
Item 12.
I apologize, my lord. Regarding item number 4, my lord, my senior Mr. Yukinen was selected in some other court, my lord. So my senior name may be recorded in the for the petitioner, my lord.
How can you record your senior's name when he's not?
Mr. I'm here on behalf of Mr. Yukinen, my lord. Item number 4, my lord. I'm sorry, my lord. I apologize, my lord.
So you are in adjournment,
Yes, my lord.
then cancel that order.
Yes, my lord.
Mr.
A Boro, my lord. On
A.
behalf-
Borough Learned Council. Appearing on behalf of Mr. U.K. Nair, Learned Senior Counsel for the petitioner. Praise for adjournment of this matter. Stop it. Mr. Who was there? Architect. Learned Deputy SJ is present for the respondents. Please, the matter
After 3 weeks, my lord.
after 3 weeks.
Oblige, my lord.
Item 12.
Okay.
I'm sorry, my lord, so I could not call on this fast.
Lordship, live streaming
My
is
lord.
on.
Here in this case,
Stop.
appeal was admitted, record has been called for. My friend has also.
From the place of occurrence. That is the one of the circumstances she stated. That the circumstance which he mentioned, he identified those agreements through Saki. But that Saki was not produced before the my lord learned trial court or nor seized by them and produced before the learned trial. That is the fatal the prosecution case. Here in the instant case, what happened, my lord? A sketch map has been prepared, my lord. This judgment I am using for two purposes, my lord. That sketch map has been prepared, my lord. In that sketch map, my lord, the tube light, they have said there is a tube light, my lord. In this case, my lord, there is a tube light, and on the basis of that tube light, he identified the accused person. But in sketch map, that tube light is not available. The learned, the apex court has, the honorable apex court has said it is fatal the prosecution. Paragraph 7, my lord, 171. I will also got it. State of MP versus Goudon. 2013 2012 versus 485. Para 7. From the evidence of PwC.
Just take a break.
Para 7.
After 10 minutes.
Yes. Proved by the prosecutor. The benefit of omission to the point of the existence of such light in sketch, in our opinion, should go to the accused. Here, she said, I am coming along with the Saki and identified the accused person. That Saki was not produced before the learned trial court. And another important thing is that the sketch map in the instant case, because sketch map has categorically stated, my lord, this place of occurrence is 300 meters away. I have shown, my lord, last time. away from the rented out of the deceased person, my lord. So 300 meter, my lord, dark night, it is not possible, my lord, to identify any person, my lord, in the incident case, my lord. This evidence is available here, my lord. In the sketch map also that was available, my lord. So considering all these things, my lord, I have already stated PW1 improvement statement, that part, PW5 improvement statement. If you wipe out all these things, my lord, basically he was convicted on the evidence of PW1. Considering him as eyewitness, although he is not eyewitness, he is a, my lord, person who come immediately after the incident. If your lordship is not considered the first time statement before the court, there is not at all any evidence against the accused person to convicting in this case, because, my lord, seizure was failed, my lord, recovery was failed, everything has been failed, my lord, in this case, my lord. FSL report of the wearing apparel, bloodstain, nothing has been taken, my lord. Everything, and the sketch map said 300 meters away from the place of occurrence, and the person who has, my lord, informed that person, my lord, from the fire brigade was not informed, not examined before the court, my lord. So considering all this thing, my lord, I may be acquitted from this case, my lord, subject to what my learned friend has said before your lordship.
May please, your lordship. As far as the conclusion of the learned trial court is concerned, that she will be considered as an eyewitness. In my humble submission, this will not be proper, because here 161, as your lordship knows, as has been held by in Tehsildar Singh's case also, 1959, lordship will know. There in Tehsildar Singh's case, it is said that 161 can be only for contradiction, no other purpose. And 161, of course, that case was under that case, the Honorable Supreme Court dealt with the contradictions mainly, was section 145. But while dealing with 145, Honorable Supreme Court has said, in my whatever I remember, is that in certain cases, few words can be implied. Like a witness, if he says before the police that Mr. A has only killed Mr. B, only Mr. A has killed B. And before the trial court, she says A and C has killed B. So in those cases, Honorable Supreme Court in Tehsildar Singh's case said that it can be implied, the word only can be implied, that means only A has killed B. And in that manner, contradiction has to be proved. So here, there, Honorable Supreme Court said certain facts which the witness doesn't say before the police officer, but says before the trial court, certain words can be implied, seeing the sentences, seeing the statements, the facts. But here is a case where the PW1, she said, I have seen both of them assaulting my husband. I have seen her 161 statement. 161 statement, the way it is being projected here, the way it is being contradicted, was couched in a different language. I have seen her 161. 161, she has clearly said, I have seen both the persons assaulting my husband, killing him on the spot, and then running away. 161 is like this. But in her trial statement, she did not say, I have seen them killing. She said in the very first statement that these two persons has killed my husband, but not in so many words that he has killed my husband. These two has killed. So by applying Tehsildar, we cannot imply, in my humble submission. So 161, whatever she says, differs to a certain extent in her statement before the trial court, not to the extent of being hostile witness, but to a certain extent. So the learned trial court's conclusion that she'll be an eyewitness, in my humble submission, will not be proper. This is a case of circumstantial evidence. Now, before going into the circumstances, I would like to address on the submissions made by him. One is that he said that GD entry, about the GD entry thing. GD entry I have seen in the entry that is made in the general diary. There it is said someone, an unknown person have killed the deceased and he is made lie on the ground before the fire office. Nothing more than that. It is only that few people, somebody has killed the deceased and his body is lying. And then if police is informed, and they should need to come and investigate. So there is a judgment, Lordship will remember, Yanav Sheikh versus State of, I've mailed it, Lordship can see that. There it is dealt with, this concept is dealt with, whether a GD entry will consider as an FIR and under what circumstances will not be. So Yanav Sheikh, Lordship can see, I have mailed it to Lydiana. Oh, etc. They have taken out perhaps. This is now Yanav Sheikh, I'll just tell about the facts. There what happened? Yanav Sheikh got into a quarrel with the deceased over some water pumping issue, some water being led through the pumps. And then there was a quarrel first. Thereafter, in between the quarrel, he went back home. He brought bombs from his home and he hurled the bomb on the deceased. And the deceased died. And immediately a telephonic information was given to the police. Police arrived. GD entry was made and police arrived, and thereafter when police came to the place of occurrence, did certain investigation, thereafter the FIR was lodged. In that context, it was dealt with whether that GD entry will be considered as an FIR. And what the Supreme Court said, in certain cases, in order to bring only the police to the place of occurrence, in those cases, GD entry will not be the FIR. Any cryptic information, that the Lordship knows, any cryptic information, short information, only to get the police to the place of occurrence will not be an FIR, it will be a GD entry. FIR will be the first information report given with particulars, few facts, not encyclopedia, few facts. So Yanav Sheikh, Lordship will see, this is all the three judgments Yanav Sheikh you can take out. State Bank of West Bengal, their paragraph 2,
Give the citation.
Lordship, it is, they're taking it out. This is 2013 6 SCC, 2013 6 SCC 428. I have taken it out from Manupatra, the same judgments. And GD entry is not exhibited. If that again is a different issue. If GD entry is not exhibited and your Lordship thinks that GD entry is important, the witnesses should have been examined, then in that case, the recourse would be to remand the case. There is no other procedure. That judgment also I'll place. Where it is considered that GD entry should have been exhibited, the person should have been examined, and Justice Ansari as he was dead, and then he had passed the order for remanding the case. But here Lordship has to first decide whether the GD entry at all is relevant in the case and whether at all it is an FIR. So here, paragraph 3, I'll just slowly read out until he takes out. Paragraph 2 deals with the facts. Before dealing with the rival contentions raised by the learned counsel appearing for parties, it is necessary for the court to notice the case of the prosecution in brief. On 19 December 1984, amongst other villagers of village Loria, these are the facts. PW8, Muhammad Sadiq Ali, PW1 hired a pump set who was examined as PW7 for taking water from the pond known as Sampukur for irrigating their respective land. Lordship can skip that, I have already said. And then why I'm placing this paragraph is that they had informed the police only to get the police to the place of occurrence. Immediately after the incident, both the accused persons fled away with the help of the villagers. Muhammad Sadiq Ali took Samim to his house, which was stated to be at a short distance. The information with regard to the incident was given to the police station through telephone. So here, a telephonic information was given. In our case also, a telephonic information was given. Lordship will go to paragraph 2, last part. Lordship will skip the facts I have already said. He took out bombs and he hurled it. Lordship will see the last but 2 lines in paragraph 2. The information with regard to the incident, did your Lordship get? The information with regard to the incident was given to Rampurhat police station over telephone.
Yes.
Yes. SIRP Biswas along with SI so-and-so arrived at Lolia around 10 p.m. on 19 December. The telephonic information on the basis of which the GD entry number 708 was lodged was made by PW6 on a phone booth. After these officers arrived, Sadiq Ali submitted a written complaint. Exhibit 1 addressed to the officer in charge, Rampurhat police station, made an endorsement and so. Lordship will see thereafter in the explosives were received. He prepared the inquest report over the dead body of the deceased on identification of the same by his brother. The sketch map of the place of occurrence was prepared. The pump set was seized. Jimbanama was prepared, collected the postmortem report, so. So this proceeded after they received the complaint at the place of occurrence. Thereafter, this Yanav Sheikh was convicted. Thereafter, Lordship will go to paragraph 7, 8, and 9. After 2, 7, 8, and 9. The 7 Lordship can skip, 8, 9 Lordship can go. There, 2 other cases were referred in order to see whether the GD entry is an FIR. In the case of Manu Sharma versus so-and-so, a bench of this court took the view that cryptic telephone messages could not be treated as FIR, as their object is only to get the police to the scene of offense and not to register the FIR. The said intention can also be clearly culled out from the bare reading of 154 of the code, which states that the information, if given orally, should be reduced in writing, read over to the informant, signed by the informant, and a copy of the same to be given to him free of cost. Similar view was also expressed in Andhra Pradesh versus Padurunga. This is 2009-15. Certain facts have been rightly noted by the High Court, where the information is only one which required the police to move to the place of occurrence. And as a matter of fact, the detailed statement was recorded after going to the place of occurrence, the said statement to be treated as FIR. But where some cryptic and anonymous oral messages which did not in terms clearly specify a cognizable offense cannot be treated as FIR, the mere fact that the information was the first in point of time does not by itself clothe it with the character of FIR. The matter has to be considered in the background of sections 154 and 162 of the CRPC. A cryptic telephonic message of a cognizable offense received by the police agency would not constitute an FIR. Thus, the purpose of telephone call by PW6, who when admittedly he gave no details, leading to the recording of the entry Exhibit 7, would not constitute the first information report as contemplated under 154. The reliance placed by the learned counsel appearing for the appellant upon the provisions of 162 of the code is not well-founded, even in case of Rajeshwar Majhi versus State of Jharkhand. Another bench of this court took the view, we are not oblivious of the fact that a mere information received by a police officer without any details as regards the identity of the accused or the nature of injuries caused to the victim, name of the culprits, may not be treated as an FIR, but had the same been produced, the nature of information received by the police officer would have been clear. So this is what the Supreme Court said. I'll just read out a GD entry once. GD entry, I'll translate it. It is not very long. GD entry, there what I had seen, he has given the information over telephone that so-and-so is killed and his body is lying before the fire office, without giving any other details. This is the GT entry. Etia Apunak so and so number. This is 651. Awesome. He can read the SMS very nicely, so he can read it. A2 Sasi.
এতিয়া উপৰোক্ত দৰজ নং 648 dated 27/7/2008 মৰ্মে সৰ্থেবাৰী নগৰত টহল কৰ্তব্য কৰাৰ কাৰণে এগি মোতায়ন কৰা ASI সুবুধ হালয়ে টেলিফোন কৰি জনাই যে কৰ্তব্য কৰি আহি থাকোতে সৰ্থেবাৰী অগ্নি নিৰ্বাপক বাহিনী কাৰ্যালয়ৰ PW ৰোডৰ ওপৰত তামুলী ফুকনৰ কুশল ডেকা নামৰ মানুহজনক কোনোবাই হত্যা কৰিছে
So what he said is,
আৰু
at that time when he was coming through that road, some person has killed Kushal Deka
পিছকে কৰিম নে
before on the PWD road.
আৰু ঘৈণীয়েকজনীৰ ওচৰত কান্দিয়া
And the wife was
Ase.
crying near.
গতিকে ঘটনাটো তদন্ত কৰি বিহিত ব্যৱস্থা কৰিব লাগে বুলি জনোৱাত প্ৰতি দৰজ দি এইটো কি পাক দিছে বাপৰে পৰীক্ষাত দৰজ দি তাৰমানে এন্ট্ৰি কৰি আৰু মই OC তদন্ত কৰি ব্যৱস্থা ল'বৰ কাৰণে যত্নবান থাকিলো প্ৰকাশ থাকে যে উপৰোক্ত দৰজ সকাল তদন্তৰ বাবে ASI SC হালৈ
So he informed him to get the police and the police was sent. This is what the GD entry is. Now here, the only fact that it can be revealed from the GD entry is that so and so is killed by someone and his body is lying before the fire station. So here in my humble submission, GD entry cannot be the FIR. And the police in PW9, Lordship will go to page 31. There the police, the IO said, he had done only preliminary investigation after the GD entry. Page number 30, Lordship will go to the second paragraph in the cross, the first paragraph in the cross examination. The first paragraph in the cross examination, the Lordship got. I visited PO at about 9:15 on 27/7. On 27/7, an entry number being 651 was made in the GD. As per the GD entry, the place of occurrence is a PWD road in front of the fire station. I did not note down the distance of the PWD road in the case diary. I did not write in the GD entry as to in which direction the PWD road, the PO is. Preliminary investigation was done on the basis of the said GD entry. I drew exhibit 7 on the basis of the GD entry. I recorded statement of the witnesses on the basis of the said GD entry. I held inquest at 8 a.m. 8 a.m. is after the FIR is lodged. FIR is lodged at 6 a.m. on 28/7. So what he did is preliminary investigation. He drew the sketch map and he recorded the statements. Let me see whether he recorded the statements. Yes, he recorded the statements on 27. But otherwise, the recording of statements were all on 28. Gunabala was, her statement was recorded on 28. The date is there. And others, yes, Amit Deka also 28. Chandrakanta also 28. Moni Patwari is 29. So statements, as he said that I recorded the statements from the case diary, it seems that recording of statements were all on 28. I'll flag mark it, Lordship can see the date there. This is the flag mark where the GD entry is here and subsequently the statements which were recorded admittedly on 28. So admittedly on 28 statements were recorded, only sketch map was drawn on 27. Preliminary investigation. So in my humble submission, GD entry is not the first information. FIR is the first information. This is my first argument. Second, he said that about the 313 statement. 313 statement, Lordship knows that Every incriminating circumstance has to be put to the accused. The requirement is every incriminating circumstance. Now here, what he said, few circumstances were not put. One circumstance that he said is 12 feet. Other circumstance subject to correction, I've not heard from him. The first question that was put to Mukul Deka, Lordship will go to page 33. Page 33, the first question.
Clarify. One thing is that, my lord, an argument I have gone, 12 feet has not been considered when the petitioner is convicting the accused person. That we consider one another.
Okay.
Not
But 313 also it was not put.
put.
Not put, he
Yes.
said 313 it was
Even
not
it was
put.
not considered.
PW1, Lordship
12
will
foot.
see the question, first question. Srimati Gunabala Deka stated that on the fateful day, at about 8:30 p.m., while her husband Kushal Deka was proceeding to home, you near the home murdered her husband near the home. Otherwise, near the question is also not very correctly set. Murdered her husband by inflicting knife blow, and she, on hearing the alarm of her husband, rushed to the spot and found you fleeing away on a bicycle and carrying knife on your hands, and she saw cut injury on the neck by knife. What do you say? Now, this question, Lordship will see the incident had taken place near the home. This is given. This is posed to the accused. Near the home. So it is 12 feet. So what required? The requirement is that all circumstances has to be put. And the subsequent requirement is that he should show the prejudice caused by not putting that circumstance. What is the prejudice caused? Here, question involves near the home. 12 feet is very near. A sketch map shows it is right in front of the house of the accused. Lordship can see the sketch map once.
Both these both passes on.
There was a sketch map.
Page 74, my lord.
74, Lordship can see.
Place of occurrence is near the tree, my lord. If your lordship go to
But
the
one can see from her house. It is only 12 feet.
place of occurrence, page 74.
The place of occurrence is fire brigade office is on the left side.
No, Gosor Kahot আছে।
Oh, Gosar.
And
Right
that is,
side, these are
and that is
cultivated.
300 meters. Fire station and the rented house of the company at a distance of some 500 meters. Page 75. Next page to sir.
Oh, yes, yes. Is at a distance locality of Musalman Supa.
No, it is on the next to. No.
Fire station and rented house at a distance of 300 meters.
Uh,
So the rented house is
That
on
is
the,
between the fire station and the house.
yes, my lord.
yes.
That is 300 meters, my lord.
And the body was lying just on the right side of the fire brigade office.
Not left side house, right side of the fire brigade house.
The left, enake saisho?
Uh,
Left side is the fire brigade office. Right side is the house of Kushal Deka.
Mm.
And the body was lying just on the A2. Right side of the fire brigade office.
Yeah.
Or whatever.
mm,
So this is very near
very
to
nice.
the house. And it was, and the occurrence was in the evening at 8:50 p.m. It's a village area. So what my submission is in her statement before, in the statement under 313 CRPC, the nearness of the place of occurrence was put to the accused and he answered it. There is no prejudice caused. In that respect, Lordship will see one judgment, Narsing, 2015 1 SCC, 2015 1 SCC. There, the Honorable Supreme Court has said that the accused has to show what prejudice is caused.
Page
2015 1 SCC 496. Yeah, yes, sir. Huh? Oh, library. I'll read out very slowly, Lordship. 2015 1 SCC 496 paragraph 20. Only one paragraph. I'll read out. The question whether a trial is vitiated or not depends on the degree of the error, and the accused must show that non-compliance of 313 Code of Criminal Procedure has materially prejudiced him or is likely to cause prejudice to him. Merely because the defective questioning under 313, it cannot be inferred that any prejudice has been caused to the accused, even assuming that some incriminating circumstance in the prosecution case had been left out. Here, when prejudice of the accused is alleged, it has to be shown that accused had suffered some disability or detriment in relation to the safeguard given to him under 313 of the CRPC. Such prejudice should also demonstrate that it has occasioned failure of justice to the accused. The burden is upon the accused to prove that prejudice has been caused to him, or in the facts and circumstances of the case, such prejudice may be implicit and the court may draw an inference of such prejudice. Facts of each case has to be examined to determine whether actually any prejudice has been caused to the appellant due to omission of some incriminating circumstances being put to the accused. So what prejudice that has caused to him? Otherwise, the occurrence has taken place near the home. It's there. It's visible in the question. It was very much there. So in my humble submission, there is no prejudice caused. Incriminating circumstances, which all the witnesses have said, has been put to the accused, and he has answered everything in negative. This is my second submission. And if the GD entry that I was just saying, GD entry was not exhibited, then what happens? In that regard, of course, I think they are bringing it from the library, that Honorable Justice Ansari's judgment was there in Virsa Kurmi versus State of Assam. There the case was remanded. I'll read out, it's a very small judgment. Virsa Kurmi. This is, I'll read out paragraph 14, 19, and 21.
Citation.
2013 4 GLT. 2013 4 GLT 1017. Para 14, 19, 21. I'll read out slowly. While considering the present appeal, what attracts the attention most prominently is that, though the case in hand, Exhibit 1, which was the Ejahar lodged by Arjun Saikia at Digboi Police Station, has been treated by the prosecution and the learned court as the first information report of the case, what cannot be ignored is that it is the evidence of PW1 that at first Apurva Saikia informed over phone about the occurrence of their village men, and after about 45 minutes, police came to the place of occurrence along with Apurva Saikia and found the deceased dead body lying on the backside of the hardware shop, and he therefore went with the police to Digboi Police Station and he lodged the Ejahar. So police was brought, Apurva also came, and the body was found. This is the fact of that case. Then paragraph 19. Situated thus, it is clear that Exhibit 1 could not have been treated as a first information report. Here is a case where GD entry was considered as the first information. In that context, it is said, there was thus serious lapse on the part of the prosecution as well as the learned trial judge in not examining Apurva Saikia, who had, according to the evidence of PW1, informed their village men and also the police officer in charge of Digboi Police Station, namely Hanan, and also bring on record the general diary entry, if any, which might have been made at Digboi Police Station before the police personnel had moved out of the police station to visit the place of occurrence and investigate the offense which has been reported to him. Non-examination of Apurva Saikia and Abdul Hanan as witnesses and omission to bring on record the general diary entry, if any, which might have been made before the police personnel had moved out, are serious lapses. In this particular case, it was considered as serious lapses. Now here, the GD entry was recorded by DK Das, the SI. DK Das, the SI, and the person who has informed is Subodh Haloi. Subodh Haloi, he was working in the fire station thing. Of course, in our case also, both of them were not examined. But in my humble submission, since I have already shown that it was only with the effort to bring the police to the place of occurrence. So in my case, the FIR will be the first information, not the GDN. In that case, Lordship considered that that was not the FIR. GD entry is the first information, and therefore it was considered. Then paragraph 21, in this particular judgment, Honorable Justice Ansari, it's a division bench judgment, Lordship can see. 21, I'll read out. In the light of the law as discussed above, one cannot ignore the fact, and we must point out that the conviction of the appellant without bringing the contents of the general diary entry, as well as the evidence of the officer in charge of the Digboy police station and Apurva Soikia, were serious infirmities in the trial, and in the face of such infirmities, the conviction cannot be sustained, and the present case needs to be remanded back to the learned court for disposal in accordance with law. So that was remanded. But everything depends on facts and circumstances, Lordship knows here. Now here, they came, FIR was lodged, and thereafter entire investigation took place. Wife had come, deposed, brother had deposed. In these facts, I don't think so any infirmity has been caused. And I'm saying that GD entry here is not the first information came later. It is only an information to bring the police. On the sake of repetition, I'm saying. So these are 27 recovery and all, I'm not going. Because neither the police had said that he has stated he will show the articles. The independent witnesses who have deposed have changed their statement before the trial court. In their 164 statement, they said, yes, he was brought and the knives were recovered. But 164 can be used only for corroboration. I cannot corroborate. Neither any, and from where it is actually brought out, I cannot place from any substantive evidence barring 164. Only in 164 statement, it is said that Abades Tamuli Niki, that PW Alokesh Burman had brought out. But none in other substantive evidence, it's not there. So 127 recovery, I'm not going. So now I'll place the circumstances that would be relevant in this particular case. And how far contradiction has come into the picture. Now the first circumstance, PW1 had said that deceased was working at the place of the accused. PW1 had said, Lordship will see that deceased PW1 had said that deceased was working as a brass metal worker at Mukul's house. Good facility. I got that statement somewhere. He was working as a brass metal worker at Mukul's house. What is it? I'll show that it is in the evidence of PW1 that this deceased was working with the
Page 11,
page 11. Lordship got it.
somewhere from,
Yes, I got it. Before my husband's death, as he used to work as a brass metal worker in the house of accused Mukul, we had visiting terms with him. So they know each other. Mukul is known to Kushal. They know each other. Secondly, deceased had a quarrel This is in the evidence of PW5. Lordship will go to PW5. Second circumstances, there was already a quarrel before the occurrence. Page number 19, PW5. Third line, in the afternoon, on the day of occurrence, deceased Kushal Deka had a quarrel with accused person over some money related matter. Because they were working each other, there was money issues. So they had a fight in the afternoon. Then the accused persons threatened Kushal. Lordship will see the next line. Then the accused persons threatened Kushal that they would cut and assault, kill him. Threatening is also there. In the evening on that day, accused persons were lying in ambush near a pawn shop. Seeing me, the accused person hid themselves by covering their head and faces. At that time of leaving his workplace, Kushal Deka asked me to accompany him. But I told that I would leave the place after some time. After about 10 minutes, Kushal arrived in the front of his house. Accused Dipankar caught hold of his hand and accused Mukul Deka's sword. Now, this is not relevant because he had not seen. As far as quarrel part, the threatening part, let us see what contradiction has been brought on record. Lordship will go to next page 32. The contradiction of PW5. Page number 32. Paragraph 2 of page number 32. Lordship got it. Witness Anil Deka did not tell me that when Kushal had reached their house, accused Dipankar had held him by hands and Mukul saw him. That is why I've removed this. And when Kushal had screamed, Gunawala came and accused person left the place by means of bicycle. That many person had gathered at the PO, that on being asked, Gunawala narrated the incident, that he had seen Ripun Deka, Orun Tamuli and other person at the place of occurrence, that he had carried the dead body in a push cart when police have arrested, they had confessed. So as far as quarrel part, as far as threatening part, hiding their faces, and they were lying in ambush near the pawn shop. There is no contradiction. So these becomes part of the circumstances. They have seen, the PW5 had seen them in near a pawn shop and hiding themselves. When he saw the PW5, they hid themselves with clothes and all. So that becomes the next circumstance that PW5 had stated these days. Then, in the meantime, PW1 came after she heard the shouts. Third circumstance is that PW1 reached the place of occurrence. Now, how far PW1 statement can be relied on? Now, PW1, what she stated, that page number 9, PW1 had stated, around 8:30 p.m. while my husband was returning from Hottebari market, both the accused persons killed my husband a little away from our rented house by stabbing him with knife. Now here, she did not say that I have seen. She simply said, accused persons had killed my husband. At that time, I was standing in front of the house and I heard my husband scream. Hearing my husband scream, I came to my husband in a run, and reaching the spot, I saw both the accused person fleeing scene on a bicycle. I noticed knives in the hands of the two accused person. I saw cut injuries. Now there are again contradictions, as my learned friend had shown. Lordship will again go to page 32. What are the contradictions that were proved by the IO? Page 32, first paragraph. Witness Gunawala Deka did not tell me that on the day of occurrence, they had been in their rented house. That a little distance ahead of their rented house, the two accused person had caused her husband injury with knife. That on the day of occurrence, she had been asked to prepare rice, that on being told, so she had been waiting at the gateway, and that going in a run, she had seen the two accused person armed with knives flee from there by means of bicycle. Now here, My humble submission would be, these sentences were couched in a different manner. In her 161 statement, she said, I'll read out her 161 statement and I'll translate it sentence by sentence. In her 161 statement, she did not say the bicycle, she did not say about the knives, but she said about leaving the place. She said about the accused fleeing from the place. That is there in 161.
161 statement cannot be, my lord, read by this person, my lord, by the prosecution, my lord, for, my lord, convicting the accused person.
I'm not
Only
reading
for
for that
acquitting the
purpose.
accused person. Because what evidence is available in the, my lord, case record, that will be considered.
No,
Other
we
will
will
not be.
reply,
This is- I can produce the
What
many
I
judgment.
have said on the very first incident, it's only for contradiction, no other purpose. But why I'm placing is that here the contradictions was couched in a different language. For greater justice, Lordship has to see what contradictions. As far as fleeing away is there, on a bicycle with the knives, those are not there. I'll just read out for, he can reply anytime. This is a very short statement. 29/7 तारीख है राती अनुमान 8:30 मान बजात 8:50 मोर पुरोनी मोर पुरोनी तो নহয় मोर Tami.
বজাৰত
বজাৰ
কৰিবলৈ গৈ ঘূৰি আহি অগ্নি নিৰ্বাপক কাৰ্যালয়ৰ ওচৰত আহি থকা
অৱস্থাত আহি থকা while he was coming back from the
Yes,
market.
and he's about to reach his residence. অলপ দূৰত্বত মই মোৰ স্বামীক মোক নামাৰিবি বুলি চিঞৰ বাখৰ শুনি
That is there. That shouting, that screaming part is there. That is not contradicted.
মই তাৰাতাৰি চাকি লৈ দৌৰি গৈ দেখা পাওঁ যে শ্ৰী মুকুল ডেকা আৰু শ্ৰী দীপাংকৰ ডেকাই আগভেটি ধৰি মোৰ স্বামীক চোকা অস্ত্ৰেৰে গলত ঘপিয়াই দিয়ে আৰু মোক দেখা পাই তেওঁলোকে ঘটনাস্থলীৰ পৰা দক্ষিণ ফালে পলাই
যায়. So fleeing away, screaming, those parts are there. Apart from that, what she stated, I have seen them hacking on the neck. So the contradictions that are being proved or projected to have been proved are in a different language. It's not that she had not seen anything. She had not seen them fleeing. What she had not seen, what we cannot deduce now, is fleeing by a bicycle or with the knives. But fleeing away from the place of occurrence is there. Screaming part is there. So PW1 reaching the place of occurrence on hearing the screaming and seeing the accused fleeing away from the place of occurrence can be read in the evidence. This is my humble submission. I'm not saying 161 to be relied on. That part can be read in the evidence.
Cannot be looked for convicting the accused person. What my learned public prosecutor has done, my lord, that for the convicting the accused person, 161 has been read. That is not permissible under the law because he's IO, my lord. This is not my witness. His witness has stated before the court, my lord.
Yes.
And his PP is available, my lord. Now he is reading from the one, that is not permissible under the
You reply later on.
He can reply later on.
Spend.
So 161, why I'm repeating that in order to see what are contradicted and what are not. We cannot just simply brush away from the justice that everything she contradicted. The words are couched in a different language. What the police have said, she had been waiting at the gateway and going in a run. She had seen the two accused person armed with knives fleeing away. Fleeing away, she had seen. So the next circumstance would be PW1 reached the spot and she saw the accused fleeing away. And the spot is how far? It is only 12 feet. Very near to the place of occurrence at 9 o'clock. In the rural areas, there'll be none. So there is every possibility she had seen the accused fleeing away from the place of occurrence. Then the homicidal death, Lordship has already seen, the doctor has said, it was by cut on the neck. This is PW 8. This is, he had said that this is wrongly written. The approximate time of death is 6 to 10 hours because in the PM report we have seen 6 to 18 hours. So that matches with the death, and the death was due to cut on both sides of the neck. This is an homicidal death. Then the recovery of the knives. Now, recovery of the knives. Lordship will go to the seizure list once. I'm not harping on 27 recovery, but the weapon of assault were recovered. Page 57. What the IO writes, seized the below, I so and so seized the below descriptive weapons in connection with the above referred case shown and identified to the police and witnessed by Shri Mukul Dekar, which were kept concealed in the hand of Alokesh Burman. This will not be taken into consideration. So the description of the seized articles: one double-bladed iron knife with wooden handle. Its length is around 9 inches. Mark of blood is not found in the knife. One iron dagger with a handle, without a handle, the length of which is around 10 inches. Mark of blood is not found. So 2 daggers were found, one without a handle and one with a handle, in connection with this case. 164 of 164, Lordship will just go once, subject to correction how far I can corroborate it. Page number 60, this is Ripun Dekar. Page number 60, that is PW number 5. What he said before the magistrate: Kushal Dekar was murdered some 2-3 months ago. This is at page 61. We went to the police station yesterday on behalf of the public demanding punishment to the murderer. We saw 2 accused persons at the PS. The OC of the PS told us that the knife used by the accused was at Namla village, and he asked us to accompany the police party to that village. Reaching Namla, we went to the house of a person. There, one boy took out 2 knives from a ditch and handed over to the OC. At that time, accused Mukul Dekar showed the knife that he had used in committing the murder. Among the 2 knives, one had a handle and other was without a handle. But once, this is 164, which I can use only for corroboration, nothing else. So here he had not stated those things before the trial court. So other 2 witnesses are also there. Arun Tamuli is there. Alokesh Burman also said that knives were taken out, but not to that extent. I cannot say that is 27 recovery. What I can at all say that knives, the weapon of assault, were recovered, and that can become a circumstance, a chain of circumstance.
Continue at 2.
Lord.
Can it be 230, my lord? I have a case, my lord. Fix at 2.
Because otherwise I have nothing more to say. These are the circumstances. And if your lordship wants me to write down the circumstances, I can write it down and give it by tomorrow. But lordship, it will be here, I suppose. So
Monday, you can give your written out.
yes, written
Yes,
those
I shall give the
circumstances
written.
I can put. Otherwise, I have
At 2
nothing
mile.
more to say. These are the
Yes.
circumstances.
One thing is that, my lord, before his submission, it will conclude question here.
Ah.
I can say one word, my lord. If your lordship go to the IO statement, my lord, another important point I found, my lord. There is a statement occurred on the
We'll come back at 2.
yes, my lord.
Lord.
Sorry for interruption, my lord. I in respect of item number 26, my lord. Our part already completed, my lord. So far, my knowledge and experience goes. So in respect of.
No. Here in this matter, Mr. Diwari is the,
He's there.
Yes,
Acha, you case hold of Mr. Kalita and come.
He's a junior is there.
Okay. This is a matter where we have kept it reserved.
yes.
Judgment. But then we found out that there's another, one co-accused has filed another appeal.
Correct.
So we'll have to hear that also.
Yes, my lord.
So obviously.
He
this,
has to be heard. My lord, otherwise, you will be prejudiced, my lord.
Therefore, we have to release it from,
But our part is closed, maybe treated as a closed.
no,
No, my lord.
There will be a different bench sitting.
Yes, if it comes before different bench, we need to appreciate the court again. We need to advance our
At two
Oblige.
will pass the orders.
oblige a lot.
Lordship, we haven't received the paperwork, Lordship. On behalf of.
That's CAV matter.
CAV matter.
26, 27.
Mr. Kalita, in the other, your appeal, I don't know whether the paper book is ready.
No, actually, Lordship, today only I got to know that I have been appointed as an amicus. I
Okay.
was not aware of anything about this.
Okay.
So the matter went on, the matter was heard.
Oh,
The thing is that like today only I got to know, so I'll have to collect the paper book, then only I'll have to.
okay. Give the file. In this third ayat al-Quran, and it's also to the appellant in criminal appeal number 287 of 2019, as well as Mr. A. Tiwari, Leonard Amicus Curiae, in criminal appeal J number 15 of 2018. Hearing was concluded in these two criminal appeals on 29/5/2022, and that one was however, it has been brought to our notice that there's another appeal filed by authorities, namely namely criminal appeal within bracket J 16 of 2020, isn't it?
Yes, my lord.
16 of 2020. Shyamoli Biswas within bracket versus state of Assam.
Yes.
Accordingly, this matter is released from is released, and this two criminal appeals is directed to be listed along with criminal appeal jail 16 of 2020 after. You will require some time.
I request sometime, Lordship, because paper book has to be, I mean, given directed to be given to me
We'll do it after 4 weeks.
4 weeks. So Lordship may kindly direct for paper book to be given to me, some kind of.
I don't know if paper book is ready in that matter. Because so far the latest orders are concerned. No direction.
No
Let's-
direction.
no, Let's see.
Okay.
After that, we'll pass appropriate orders.
Lords.
In respect, my lord, if I am not mistaken to address, in respect of our both the cases, the order will be passed
Release.
or released.
Release.
If, my lord, if it is released, most valuable time of the honorable court will is become hostage.
The problem is,
But
have you heard me properly? Have you heard me passing the order?
I unable to heard. Comfortable.
There's another jail appeal filed by co-accused.
Yes,
Now, if that is not heard along with your two criminal appeals,
yes.
the case of that other person will be.
Prejudiced.
prejudiced. So how do we pass judgment in these two criminal appeals
Yes, because
without hearing the other?
This bench may not remain, that is the difficulty perhaps.
So we are releasing it.
Then,
Then after that, it will come up. with
Lordship.
the other-
Lords. Oblige.
Oh, it's just on top, would also hurt MSB Buyan, learned additional. Yes.
Lordship, registry may be directed to prepare the paper book because
That we don't know whether.
because
the-
SCR will be here along with these two matters, my lord. And Shamoli is, since it is like taken up separately.
LCR registry is also directed to prepare the paper book in criminal appeal jail number
287 2019, criminal appeal 287, 2019.
No. That new, the
Shamali,
16.
Shamali.
16, criminal appeal
16
16.
of 2020, if not already prepared.
Yes. Registry may verify it, my lord.
Lords.
Well, in the instant case, my lord, I shall give reply what the prosecution has said, my lord. Basically, prosecution has said, my lord, 4 things, my lord. One is that, one is that there is a motive of murder, my lord, because I know the accused person, she has stated. But same PW1 has categorically stated, I am coming, my lord, on that paragraph, my lord. PW1, evidence of PW1, my lord. Cross-examination part, my lord. From page 11. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 line from the above, my lord. My husband. Have you also got it?
Yes.
Page 11. 10 from top. My husband. Right side, my husband. My husband. My husband never told me that he had enmity with the accused persons. There is no motive of murder, my lord. Next, she rely on PW5, my lord. What PW5 has stated in, my lord, page 21. Page 20, have you lordship?
Yes.
Page 21, my lord. Your lordship kindly come from the, my lord, top. List of occur. At the time of shop was opened, have your lordship got it? From the top, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10, my lord. From the above 10 line, my lord. At the time the shop was open, at the time some other youth were present near shop. I stated to police, I had seen the owner of the shop, other youth. The police recorded my statement only on the date of occurrence. This is important, my lord. Police recorded my statement only on the date of occurrence. But if your lordship goes, he said, the statement has been recorded on the next day, 28. All the accused statement has been 28 or 29. Meaning thereby there is a statement on that particular day, and that has been withheld by the prosecution, my lord. I don't know what is the reason they have withheld the prosecution. Everything should be done under the statute. If that is, my lord, withheld by them, my lord, is no evidentiary value, no value in the eye of law, my lord. Police record on the date of occurrence. Thereafter, I did not make any statement before police. Meaning thereby, next day he did not make any statement. Have you also got it, my lord? Yes, ma'am. Exhibit 5 was a written paper. I put my signature there. Contents are not read out me. At the time of Exhibit 5, Gunawala was not present in the police station. I did not state before the police. The incident had taken place around 6:30 p.m. one day about 6 years ago in the afternoon on that day. This is first quarrel. Kusal had a quarrel with the accused person in course quarrel. Accused threatened the Kusal they would cut and assault, kill him. That statement first time she made before the court, my lord. And she categorically stated that his statement was recorded on that day. Next day, no statement has been recorded. And it was corroborated by police also, my lord. I will come, my lord, later on. I also did not state before police that on the date of occurrence, accused person were lying ambush near a pawn shop, that seeing me, accused person has hide themselves by covering their head, faces, and at that time, leaving workplace, Kusal Dakar asked me to accompany him. I had told him to leave the place. That statement was not made before the policeman. First time she made. That second circumstance also go. Now, interesting thing has come, my lord. Today she has read, my lord, the GD entry, my lord. What about the GD entry, my lord? She said that it is a cryptically recorded, my lord. And important thing is that it was not cryptically recorded because in the GD entry, as per I remember, he said, my lord, that person of the, my lord, fire brigade, my lord, as some, my lord, Halloween, has categorically stated that when I got to the place of occurrence, I saw that the Gunobala is, my lord, crying in front of the dead body, my lord. And I informed to the police, and I come to know that some unknown person has killed that person, my lord. Unknown person has killed that particular person, meaning thereby that he meet the Gunobala at that time, my lord, and thereafter he has recorded the GD entry. Important thing is that, my lord, on the basis of GD entry, my lord, the statement has been recorded, my lord. Accused witness statement has been recorded, my lord. If all the statement has been recorded, my lord, on the basis of, my lord, GD entry, my lord, the evidentiary value of the GD entry is there. Because, my lord, it is not like a cryptis. A body has been found, then police come. A statement, all the person's statement has been recorded, my lord. Your lordship, kindly go to the, my lord, again, my lord, PW 9 statement, my lord. Cross-examine part, my lord. Page 30. 651, as the part of GD entry, the place of occurrence is PW Road in front of fire station. I did not note down the distance of the case diary. I did not GD entry as which direction to PW Road. Preliminary investigation was done on the basis of GD entry. I drew the exhibit 7 on the basis of say GD entry. Sketch map has been prepared on the next. I recorded the statement of witness on the basis of say GD entry. And if you corroborate with PW 5, my lord, he said on that day his statement has been recorded. All the statement has been recorded on the basis of GD entry. Now he said that there another affair. Second thing is that important. The FIR was filed on next day, my lord. There is no explanation. Next line, when cross-examined, there is no explanation has been given why the FIR has been filed on next day. There must be some reasonable explanation. That was not there. So there is every possibility that they may develop the case in the instant case, my lord. To that extent, my lord, I have a, my lord, one judgment, my lord, I am coming later on, my lord. And these circumstances first he has said.
Chaudhary, you just reply to what the
Yes.
unit edition. Now there's no need of again going back.
I am not going on this, my lord. I only reply what the public prosecutor has said. Because public prosecutor has said 161 statement can be relied by the prosecution, at the appellate stage, my lord, whether it is permissible under the law. She said, because the evidence which has been given by the police officer.
I don't remember Jahan saying that. She said 161 can be relied for contradiction.
Yes, my lord, for contradiction by the accused person, not convicting the accused person. He is reading 161. Here in the instant case, my lord, here categorically stated, Gunobala, that, my lord, important thing, my lord. I am reading that, my lord. Witness Gunobala did not tell me that. Page 32, my lord. Yes, my lord. Witness Gunobala did not tell me on that day of occurrence. They had been in their rented house. That a little distance ahead of their rented house, two accused person has caused her husband injury with knife. That on the day she had been asked to prepare rice. Then on being told she had been waiting gateway and going round, she had been seeing two accused person armed with knife flee from my means of bicycle. That statement was not stated before the police, my lord. As per IO, my lord. It is his statement, my lord. IO is the prosecution witness, my lord. Now he want to develop the story. This has been mistakenly not stated, and she looked to the, my lord, 161. That is not permissible under the law. My lord, your lordship, kindly come to the CRPC, my lord, 162, subsection 2. 172 subsection 2, my lord.
Hmm?
Sorry, my lord.
172
subsection 2.
Yes.
Any criminal court may send for the police diary of the case under inquiry or trial of such case may be cited not as a evidence in this case. That is why I'm reading. He cannot now say that 160 has said like this, and this is the evidence. Only court can look to the evidence of this case. Because I am reading this, because I am relying on judgment in the moment. Just now I got my lord. My lord, 1997 6 SSC 171. There are 25 men.
Yes.
Yes, ma'am. Amara here na pala. There are 25, my lord. Have you also got it? We are constant to say. Photocopy. Have you got the copy? Yes. There are 25, my lord. We are constant to say the above observation has been made by the trial judge casting on the basic principle regarding the appreciation of evidence, misleading evidence. So far as the PW5 vigilance cell is concerned, trial judge failed to notice it did not condemn. I am reading the main paragraph, my lord. Better reading. The reliance of the trial judge. Have your lordship got it, my lord? That will find your lordship.
Yes.
10D, D part, my lord. Between D and E, my lord. The reliance. The reliance of the trial judge on the result of investigation to base on finding again patently wrong. If the observation of the trial judge in this has taken logical conclusion, it would mean that and finding of the guilt can be recorded against the accused person without a trial, relying solely upon the 173, which to outcome of the result of investigation under chapter 730 criminal code is conclusion that investigation draw a basis of material collected during investigation, and such court can only basis of competent court to take cognizance of trial material. The trial court is then required to base conclusion solely on the basis of evidence adduced during the trial. That line important. Only evidence adduced during the trial, not other, my lord. And it cannot rely on the investigation result thereof. That 161 statement is the investigation, my lord, statement. Only can they rely on the basis of the evidence adduced in the court, not more than that, my lord. During the trial. Since the elementary principle, we need not dilate on the point of any further equal unsustainable trials as reliance upon the statement made so and so, that is the I will produce another judgment, my lord. There is our High Court, my lord, that is not available. In my written argument, I shall give. Honorable Justice P.G. Agarwala has said, case diary cannot be looked for convicting the accused person, only for contradicting the accused person. He want to develop the case. Actually, the in 161 statement, it is available that Gunawala has saw the incident when he fled away from the place of cricket. That evidence was not available in the trial, my lord. Trial, she has stated that it is the police said this statement was never made before me by the Gunawala. So this statement cannot be the first time made before the court, my lord. On the basis of only on that statement, the accused cannot be convicted in this case, my lord. My lord, another is R. Sosi, my lord. I'll give a point, sir. কি হলে আগ মাৰি থৈছিলো যে মই নম্বৰ যে দিছিল I am relying on my loan 2013-14 SSC 266.
Yes.
Yes, man. Copy. Lots of ways copy. Yes, man. Page my lord. There are 26 my lord. Evidence given in court on oath greater sanctity, which is why the same is substantive evidence. Statement under 160 can be used only for the purpose of contradiction. Then, and the statement under 160 can be used both contradiction, corroboration and contradiction. The disjunctive word is and. Meaning, the meaning thereby is a 161 statement can be looked only for contradicting, my lord, not for corroborating, my lord. And one thing is rely on 164 statement of PW2. You will also kindly come to the PW2 statement, cross part, my lord. Page 14. Page 14. I have also got it, page 14.
Yes. Yes.
I do not know the content of exhibit 2 of Caesar list. I have not seen the seized knife in the court. I know wherefore the police seized those knives. That is, my lord, if you also go to the 164 statement, and if you also go to the court evidence, purely contradiction. Wherefore he has said, my lord, this evidence is more valuable, my lord. I do know where from those knives. It is not a fact. I have falsely, the police brought that. I have falsely stated that I saw cut injury on the neck of deceased. He himself said he was falsely deposed before the court, my lord. This witness. So, my lord, he is antecedent, my lord. How much acceptable this court, my lord? A witness is I falsely deposed before the court, my lord. That is the important point, my lord. And another
Is
important.
that the correct thing in the original?
Lordship, which one, Lordship?
A2.
PW
Two.
Two. Again.
Cross part.
Huh? Oh.
And last part, I made my statement on being tutored by police. Last line of Ripundeka. Cross.
Tortured.
PW2 control.
Ripundeka. So,
PW2 cross examination. In the meantime, actually, I was trying to find out, there was a Supreme Court judgment saying that 161 can be looked into in order to see the veracity of the witnesses. That is 1966 judgment. So I was trying to find out. I have this judgment, but in order to see the veracity of certain witnesses in the facts of the case, Supreme Court in 1956, Baladin versus State of UP, it was seen. So it's not that always 161 is totally stopped. Here I'm not saying 161 to be relied on. What I'm saying, there's a difference. What I'm saying is that in order to see what contradiction is proved,
my humble.
I'm saying that 161 can be
I
seen.
also produced some judgment of the Supreme Court because, my lord, I have also judgment. No, my lord, I am not that, my lord. The law of the land is that clearly stated. It is absolute bar to look 161 statement at the appellate stage, my lord, producing that 161. Otherwise, my lord, there is a floodgate of
No
the case.
quarrel with the
Yes, my
proposal,
lord.
no.
Just check it out.
Which
I-
one,
I-
Lordship?
I shall produce my lord judgment.
161, the cross part.
I have falsely,
Yeah, yes.
the entire part or
So that particular line,
tutored.
no, I have falsely stated.
I falsely stated that I saw cut injury on the neck. Difficult to read this assessment version. Sanata.
বৰ্ণালী পঢ়ি দিয়া না
I know এইখিনি অসমীয়াত যে এইখিনি ইমান বেয়া handwriting. এই I have falsely stated. এই নাম খোলাৰ পিছত এই নাম খোলাৰ পিছত নাম খোলা lock up. Oh, that is what নাম খোলা. They have written it wrongly.
No, নাল থকা হব।
নাল থকা.
Yes, my lord. Yes, নাল
At কৈছে নহয়?
recovered the knives at Namkola. Maybe the name would please.
এটা লিখতে হয় না। It has been two sound.
নামখলাৰ পৰা।
Then
নামখলাৰ পৰা।
তাৰপিছত I have falsely.
এইটো সত্য নহয় যে পুলিচে
সেইটো।
নামখলাৰ পৰা।
It is not a fact that I have falsely
হয়,
report
এইটো
police
কি?
before the night.
এইটো বাদে তাৰপিছত
পুলিচে নামখলাৰ পৰা কিবা চুৰি ওলাব
এই
পৰা নাছিল।
মই এইটো কওঁ।
মই মৃতকৰ ডিঙিত এটা
হুম,
কিবা জখম দেখা বুলি মিছাকৈ কৈছো।
yes,
মিছাকে কৈছো
yes, falsely stated.
মই কিবা দুই পুলিচৰ আগত কোৱা নাছিলো নেকি? মই সেই কথা মই পুলিচৰ আগত কোৱা নাছিলো।
It's rightly translated. I falsely stated that I saw cut injury on the neck and I did not state it before the police.
last line to আছে নে চাচোন I made my statement on being tutored by the police.
Tortured,
Last-
not
Tu-
tutored.
Tortured.
Tortured by the police. On being tortured by the police. Sorry. Tortured আছে নেকি?
Yeah.
অত্যাচাৰ কৰা বুলি।
হ'ব আৰু।
কোনটো লাইন?
এইটো সত্য
Last line to চোন।
নহয়।
এইটো সত্য নহয় যে মই পুলিচে শিকাই দিয়াৰ
Ah,
It is not a fact আছে দিয়া হ'ব দিয়া।
it is not a fact that I made my
ঠিক
statement.
আছে ঠিক আছে।
So he made his statement.
নহয় যে মই পুলিচে শিকাই দিয়া
No, it is not a fact আছে এইটো নহয়
It
আগত
is actually not torture, tutor
Listen.
হ'ব নেকি?
শিকাই
দিয়া।
দিয়া পুলিচ।
শিকাই দিয়া as being taught by police.
সেইটো নালাগে ওপৰ পাৰ্টত আহিল
It is
না।
not fact, so he has
It is irrelevant my lord.
irrelevant for him.
Yes my lord.
That's why we request you to read slowly and
Yes my
read
lord.
all the, without missing any words. in
Yes
between.
yes my lord.
He
I'm
skips
extremely
many
sorry.
words.
I am extremely sorry my lord.
Fast.
We started the work together with my lord Ornali Bhuya in same chamber.
my lord.
Our
Sorry,
senior
Lord.
honor said,
Okay.
you take the judgment. Then he said, hey, Manu computer Manu বেছি speed হ'ব লাগিব।
Oh God. Our sir is to say 2000, bring 2006, then we have to understand 2006 SCC. He only says to 2006 Kanana, bring 2006, then we have to understand, my lord, 2006 SCC. He was so fast, no? That's why to like catch him up.
And that is the statement, my lord. And TW5 has stated, my lord, he did not state it before the police. And he stated that the 161 statement has been recorded on the day of occurrence, my lord. So if you go all these things, my lord, there is a preponderance probability that a statement has been recorded on that particular date. And that statement was not, my lord, produced before the, my lord, before the trial court, my lord. Because all the statement which has been given 26, 27, even IO has stated that on the basis of GDNT statement has been recorded, my lord. So this GDNT is very much relevant in the instant case. Now, my lord, important thing is 313 statement. My learned friend has said that in 313 it was asked that near the place of occurrence, this incident Gunawala has said. My humble submission before your lordship is that as per sketch map, it is 300 meters away from the place of occurrence. But that question was never put to the request.
No, it is not 300 meters from the place of event.
I am coming, my lord.
Fire,
Yes.
rented house and
Yes.
the rent of the
Yes,
disease
yes, my lord.
is about 300.
Yes, my
That's
lord.
what- Let us see the.
Yes, again, my lord,
Sketch map.
again, my lord.
But otherwise,
Just-
12 feet.
Sketch map,
Page 74.
yes.
Look, your lordship, can you look to the map, my lord? At one side, my lord, PWD Road. The rented house of deceased Kusal Deka. Then opposite side of the road, fire brigade office, my lord. Have your lordship, read? And place of occurrence is the right side near the tree, my lord. And if your lordship go to the my lord, that my lord, first the renters are complained at a distance of 300 meter, my lord. And my house is right side of the my lord fire brigade office, and rented house is just left side of the left side of the my lord fire brigade office. Your lordship, kindly look that document.
I'm on that
Yes, my lord.
page 75.
Yes, 75, write down, my lord. Fire station and rented house has a complainant at a distance of some 300 meter.
So this is the distance between this fire station and the rented house.
Yes, my lord. And
Not
rented,
not the place of occurrence.
no, my lord, I am coming, my lord. Rented house in the left side of the fire brigade office. Currently look to the, my lord, sketch map. And this place of occurrence right side.
Correct.
So this distance, my lord, how much, my lord, that is that?
According to PW1, it is 12 feet.
That,
From
that
the-
question was never put before the 313 statement, my lord. I categorically state that is why the near is something different, my lord. If you ask to the village people, what is the near of this place, my lord? Then they say that Ujan Bazar is the near place, my lord. That is not like that. They have to categorically ask the question. That is why I am submitting. There in the 12 foot of the place of the house of the deceased person. That was not asked in the 313 question. That is why I asked. And this document has preponderance probability. That is why I am arguing preponderance probability. So the 300 meter away from the place of occurrence file. And left side the house, right side the fireway. And it is said PWD road near the fire brigade office. And rented house also near the PWD road. Both between the PWD road is available between the rented house and fire brigade office, my lord. That is not my statement. That is the statement of all the witnesses, my lord. That is preponderance probability. They should ask specific question that the rented house is 12 feet away, my lord, from the place of occurrence. And one question my learned friend has said, the matter shall be remanded back to the trial court, my lord. My lord, in this case, I am behind the bar for last 6 years, 2 months. In this case, my lord. And my lord, if your lordship remanded back today, it is prejudice to my accused person. If it is a case, my lord, that 1 month, 2 months, it was remanded back, then also it is prejudice because Article 20, subsection 2 says, no person shall be prosecuted and punished twice for the same offense, my lord. It is the constitution, my lord, mandate. That cannot be violated. How?
Who's punishing you twice?
I am prosecuted. What has been, I am there. No person shall be prosecuted. I cannot be prosecuted 2 times, my lord. No person shall be prosecuted. He want to that.
So according to there cannot be a retrial.
No, my lord.
No, not in this case, generally.
So far, generally, my lord,
make
can
a
be happen,
retrial.
my lord. For purpose of this case, I am arguing on this case. Because prosecution, there is some lacuna in the prosecution case. To fill up the lacuna of the prosecution case, my lord, matter cannot be remanded back, my lord. This is violation of the mandate, my lord. Article 20, subsection
That
2.
may be correct.
Yes, my lord. That is why I am submitting before your lordship.
But because of Article 20,
Yes, my lord.
it will be wrong to say there cannot be a retrial.
Yes, my lord.
Or there can be no remand.
No retrial.
That is, my lord, debatable question, my lord.
Article 22, then apply Article 22, the issue of remand does not arise anymore, is it?
Yes, my lord. As per article, I am giving some judgment of the Constitution Court, my lord. I am not saying anything, my lord. Because, my lord, sometime, now, because, my lord, to fill up the lacuna, he want to remand it back to the case to the trial court. That cannot be done, my lord. I am not going to the Article 20 subsection 2 now. That is my humble submission before your lordship, my lord. Circumstantial evidence, and my lord, three circumstantial evidence case, three should be, my lord, fulfilled. One is that it is the accused person who has committed that particular, there are no other person. Second, that the circumstances of the same should be complete. Here, same is not complete. In respect of my lord, recovery of Degar and other set. And it is the onus of the prosecution to prove the case. That three things was not, my lord, proved in the instant case. My learned friend has argued that perhaps in 161 statement, this is available. So I can take this evidence, cannot be, this court can discard this evidence. This court only go to the evidence adduced before the court, no more than that. Because his IO, my lord, her IO, my lord, put it before the court.
Cannot be charged in the consequence. Also, her as Jahan in addition to some.
It will
Concluded just one reason.
It's a file a written argument, my lord.
Yeah, you file your
Yes.
written
I'll
argument by
occupy.
Monday?
Yes, my lord.
Monday,
Give it to the court master, my lord.
Yes.
Yes, my lord.
Monday, certainly.
Twenty to 25.
Oh, my goodness. In case
Oh.
it's for my argument, your lordship, argument we made on behalf of the state, and my case raised on the GD entry, contrary to the case, the earlier case, your lordship. Lordship, the prosecution story in brief is that, your lordship, a GD entry was received by the police station concerned on a telephonic information made by the VDP secretary. Thereafter, police arrived, your lordship, because the wife of the accused person, she reported as she alleged that two accused, namely Habibur and Ajijul, came to her and on pretext of discussing some issue, my lord, the husband of the informant was taken away, your lordship, on the previous night. And when he didn't come back, your lordship, he didn't return back. She made hue and cry, in the sense she informed the village people as well as the VDP secretary. VDP secretary, on getting the information, my lord, informed the police station concerned, and thereafter, your lordship, a GD entry was made. And on the basis of the GD entry, the proceeding was initiated, investigation was initiated. And your lordship, as the information was given by the informant, that two accused, namely this one Habib and Ajijul, they have come to her residence to pick up the her husband. Village people went in search of them and they found, your lordship, and they detained them. Habib and Ajijul, my lord. In the meantime, the police have arrived. They have taken the custody of these two people, and they made disclosure statement, your lordship, and there was leading to discovery. And your lordship, thereafter, your lordship, they have shown the dead body. They have shown the place where the dead body was exhumed. It was buried, and thereafter it was exhumed, my lord. That is the prosecution case, your lordship. And your lordship, the sole basis for conviction is, in my respectful submission, would be the disclosure statement, which is admissible in evidence, as well as leading to discovery. There's last seen theory, your lordship, as well as extrajudicial confession made before the some of the witnesses, my lord. May I take your lordship to the lordship GD entry first, my lord? It is at page 90, my lord. Page 91.
Yes.
Now, VDP Secretary number 2, Kandhulimari, informs over phone that a person was murdered and his dead body was kept buried
And then in this connection, they have apprehended 2 boys. Accordingly, this GD entry is made and I, SI SK Dr. OC Dhing Police Station, along with SI Anil Bora, C1131 Bimal Hajorika, and 1 so and so APBN personnel proceed to Kandhulimari. ASI and Bordolo remains in charge. And thereafter, police visits the place of occurrence, your lordship. And it was lordship in front of a shop of PW1, my lord. May I take to the evidence of PW1 first, my lord? These are the witnesses, it be more particular PW1, 2, lordship, PW1 and 2, my lord, and 3, 4 and 5, they talk about, your lordship, extrajudicial confession made by the accused Ajijur and Habibul. In the case in hand, your lordship, name of this one Mia Hussain, may I respectfully submit, I may be wrong, but I didn't find his allegation against him. Only in the FIR, as well as in the judgment and the charge sheet, his name appears, but none of the witnesses, as well as the 2 persons, 2 accused person, Ajijul and Habibur, they have not disclosed the name of Mia Hussain. So I leave it to your lordship, to the whatever your lordship passes, lordship what order your lordship would pass, leave it to your lordship, madam. And PW1, your lordship, page 8. First, may I take the evidence of PW2, Rumena Khatun, the wife of the accused person, wife of the this one, deceased, my lord, at page 12. Page 12 of paper. I know all the accused persons. They are from my village. The occurrence took place on 14/4/08. On the day of occurrence around 6 o'clock in the afternoon, my husband Ajibur was taken away from our house by the accused persons with the information to me that they had a discussion regarding art cutting towards Romari. Accordingly, my husband went with the accused person. I was waiting in my house, but my husband did not return till morning. During night hours, some co-villagers came to my house and I informed them that my husband had not returned. I informed about the fact to Asghar Ali, one of my uncles, who has already expired. In the morning, I informed the co-villagers, the VDP and the village headman Nurul Islam. Then I went to the police station around 7:30 a.m. The police came and the dead body was recovered. Police detected the bicycle, sandals, and muffler on my husband at the place of occurrence. I was also present there at that time. The police were waiting, and when the magistrate appeared there, the dead body was dug out from the spot. The dead body was my husband's dead body. The dead body was taken by the police for post-mortem examination. Later, the dead body was handed over to us, and we cremated the dead body as per our rights. The place of digging, the dead body was spotted by accused Hobi and Ajijur. Your lordship will kindly note this part. The place of digging, the dead body was spotted by accused Hobi and Ajijur. Then I cross. I lodged the FIR on the following day of the occurrence before recovering the dead body. Before filing written FIR, I also informed the police orally about the incident. The police immediately went to the place of occurrence. The bicycle, sandal, and muffler of my husband were lying on the river embankment. From that point of the embankment at a distance of 1 kilometer inside the shore, the dead body was recovered. Your lordship will kindly note this part. The place where the dead body was dug out. From that point of embankment at a distance of 1 kilometer inside the shore, the dead body was recovered. When the dead body was dug out, I was also present there. The FIR was written by the police officer and I put my signature. In front of our house, a road is passing through our courtyard and it is a common village road. On that road, villagers used to pass. I could identify the accused when they came to our house with the help of lamp. The lamp was not seized by the police. The accused persons are my close neighbors adjacent to our house. Your lordship will kindly note this aspect, your lordship, this sentence. The accused persons are my close neighbors adjacent to our house. They are cousins of my husband. We had a dispute between the accused and my husband. Before this incident, I lodged a complaint against one of the accused, namely Fakrul, while he attempted to outrage my modesty. It is not a fact that for the reason of having strained relationship with the accused, I lodged a FIR against all of them. Today, accused Hobby is not seen in the court. Your lordship will note this part. He is not seen in the court. Dog identification is not there, that part I'll satisfy your lordship. Aizul is present. It is not a fact that no incident took place at 13408 as alleged. When my husband went out from the house, he was going comfortably with the accused. Then, your lordship, cross-examination was done on behalf of Habibur on the next page, page 14. After lodging of the Ezahar, police did not come to the place of occurrence with me. They came later on. Police went to Matikula Bazaar for investigation. Then I went there and met the police. After police had exhumed the dead body. We had no quarrel with the accused person prior to the incident. It has not been mentioned in the Ezahar that there was quarrel. The Ezahar was written by someone at Hing Bazaar. I don't know who wrote it. The contents of the Ezahar were read over to me. Having learned about the arrival of police at Matikula Bazaar, village headman Nurul Islam and witness Jahed Ali also went there with me. The village headman was informed before the arrival of police. It is not a fact that it is false that on the previous day of occurrence, the accused persons called my husband away and that I recognized them. It is not a fact that I lost case bringing false allegation against the accused person out of grudge. So, Lordship, may I pause here for a moment, your Lordship? Lordship, here, accused Habibur, the reason for not seeing accused Habibur on the day when the evidence was taken, that is on 3/4/2014, your Lordship, because your Lordship, he was in the committal court, he did not appear. He, after getting bail, your Lordship, he remained, Lordship, he was absconding. And your Lordship, as a result of which, on 18/3/2013, I have seen the printed records I'm submitting. 18/3/13, your Lordship, non-bailable warrant of arrest was issued against him, my lord. 18/3/2013.
Yes.
Then thereafter, on 28/7/15, Lordship will kindly note this part, note this date. 28/7/2015, proclamation was issued on the basis of the report submitted by the Lordship, the process server. The accused was not found in the given address. Your Lordship will kindly note that part.
Yes.
Then, your Lordship, Habibur was produced on 27/12/2015.
Yes.
2015.
Yes. By the time, the evidence of PW 1 and 2 were complete, my lord, because the date was 3/4/2014. Evidence of PW 1 and PW 2 were taken, my lord. So, committal court split up the case as against Habibur, my lord, and case was committed to the Court of Session. Then, your lordship, evidence of these PWs were taken, my lord. And on the date when after the Habibur was produced, my lord, these witnesses again was recalled, my lord. And as the witnesses have arrived, your lordship, they have appeared. Cross-examination of Habibur was taken, my lord, on 11/7/16. Next page, my lord, page 14. Date is 11/7/16, your lordship. We'll note that part. So your lordship, as he was not there, so lordship naturally PW1 and PW2 did not see him in the court, my lord. And the contention he was absconding is correct, your lordship. Now I take your lordship to the 161 statement made by
When was he released on bail?
lordship. Yes. On 16/7/08. On completion of 90 days. Lordship. May I take your lordship to the 161 statement, which was exhibited, your lordship, at page 92 to 95, as regards Aizul and Habibur, my lord. This 161 statement, your lordship, although cannot take into account, but leading to discovery part, your lordship may take into account. Page 92, my. Has the lordship found it, my lord? Got it. My name and address are as given below. It's as regards statement given by Aizul Haq. I am aged about 19 years. Regarding the incident, I have this much to say that for some days, Habi, Ajibur, Fakhruddin, Sahed Ali, Abdul Barek, etc. and I were doing art cutting work at village Romari. Fakhruddin, A. Qasim, Sahed Ali, A. Hakim have all dispute with Ajibur. Then this lordship here, Mia Hussein's name is not there. Your lordship will kindly note. They have all dispute against Ajibur.
Another person, Abdul Rahim.
Abdul Rahim, it's also not there, my lord. Abdul Rahim, his name is. Oh, he expired, yes. Lordship, out of the grass yesterday.
Expired.
Expired.
The judgment, my lord, his name is not mentioned. Perhaps at the time of trial or prior of the trial, at the time of investigation may be expired.
And out of grudge, yesterday, that is 13/4/08, the said persons told me and Habibur that they would kill Ajibur in that very night, and that Habi and I had to call out Ajibur from his residence. They made a threat that otherwise they would kill us too. They told that after calling him, we should have to take him to the embankment of village Romari. Then that they would keep hiding there.
Abdul Karim, expired. 869. Abdul Karim.
Not Abdul Rahim.
Not Abdul. Sorry, Karim.
Yeah, proceed.
That they would keep hiding there, and that as soon as we would reach near the embankment of village Romari, they would attack and kill Ajibur. Lordship, this part from Lordship, out of that grudge, till my lord, kill Ajibur. Lordship, this part, there are two parts, exculpatory and inculpatory part. Lordship, regarding that they have killed or they have killed, that will not be admissible. But regarding leading to discovery part, my lord, it will be admissible in evidence, my lord. Accordingly, at about 8 p.m. last night, Habibur and I went to the residence of Ajibur and falsely telling him that we had to collect wages for art cutting, took him with us to the village Romari on bicycle. As soon as we two, along with Ajibur, reached near the embankment, Fakhruddin came with kukri and Sahed Ali came with sword. A. Qasim came with a dao from the place where they were hiding near the embankment, the way it was planned earlier. Suddenly attacked Ajibur by means of the weapons they had in their hand and thus caused the death of Ajibur. After Ajibur had died, we took his dead body to the land of Fakhruddin's brother and buried it there following a discussion. When Ajibur did not come back to his house till morning today, he was searched for and people recovered his bicycle and sandal near the embankment. And then when Habi and I were coming towards the market, people apprehended and questioned. We confessed before the public that we killed Ajibur and kept his body buried under earth. Later on, we led police and showed the site where the dead body was kept buried. People of the village dug out the dead body. Abdul Hakim arranged the spade and other things at the time of digging of the pit. This is Exhibit 5, and Exhibit 5.1 is the signature. Next, I take your lordships to the statement made by Habibur. Page 94. My name and address are given above. I am aged about 19 years. Regarding the incident, I have to say that Aizul, Ajibur, Fakhruddin, Barek, Sahir Ali and I together do art cutting work at Romari. In the evening at 13408, A. Hakim, Fakhruddin, A. Barek and Sahir Ali told Aizul and me that they had to kill Ajibur, that Aizul and I were to call out Ajibur from his residence in the night, that we would have to take him near the embankment towards Romari, that they would be hiding near the embankment of village Romari, and that they would kill Ajibur as soon as he would reach there. They made a threat to us that otherwise they would kill us. Then at 8 p.m. on that day, Aizul and I went to the residence of Ajibur and asked him to accompany us to collect remuneration for the art cutting work at Romari. His wife objected, but when we said that we'd return soon, she did not comment. As decided earlier, we too took Ajibur by bicycle towards Romari. As soon as we reached near the embankment of Romari, A. Hakim and Fakhruddin came out with kukri in their hands. Sahir Ali came out with sword in his hand, and Abdul Barek came out with a dao in his hand from near the embankment where they were hiding and hacked Ajibur in head, back and neck. Ajibur sustained injury and fell to the ground and died after a while. When he died, we discussed and thought of burying the dead body by digging a pit. Accordingly, we dug a pit on the cultivation field of Karim, brother of Fakr, and kept the dead body buried. Bicycle, sandal, etc. are lying at the PO. We did not get time to pick the same up. As Ajibur did not return home till today morning, people started searching for him and recovered bicycle, sandal near the embankment. At that time, when both of us, Aizul and I, were coming towards the market, people apprehended and questioned us. We narrated everything before the public, led police and showed the place where we buried the dead body, and accordingly the dead body was dug out. Abdul Hakim arranged the spade and other things at the time of burying the dead body. So here your lordship will see, this is Exhibit 6 and Exhibit 6.1 is the signature, my lord. This is a disclosure statement reduced into writing. It was exhibited. Lordship, it will be admissible in evidence as regards the discovery part. Now, I take your lordship to the evidence of IO, my lord. PW9. Page 34.
Page
34, my lord.
yes.
On 14/4/08, I was as SI of police at Hing police station. Around 7:55 a.m. that day, VDP secretary of village number 2, Kandulimari, informed this PS over phone that a person was killed and the dead body kept buried, and that they detained 2 persons. The OC, SK Datta and I, along with the staff, started off to number 2 Kandulimari, and I made Hing PS GD entry number 219, dated 14/4/08. In this regard, Exhibit 4 is the GD entry book, and Exhibit 4.1 is the said GD entry number 219, dated 14/4/08. When we arrived at Kandulimari Matikula Bazaar, we saw that many people had gathered there, that 2 persons were detained. The VDP secretary and the village hitman handed over those 2 persons to the police. The OC entrusted me with the investigation of the matter. I interrogated the accused person, and they said that they had killed a person named Ajibur Rahman and buried his dead body in the field, and that they could show the place. The names of the accused persons were Habibur and Aizul. When we were taking along the accused trio, were going to the field, We saw an old hero cycle, a pair of leather sandal, and a violet color muffler lying near the embankment. Then Rumena Khatun, the wife of the deceased, identified all these things to be of her husband, and I seized these items in presence of the witnesses. Exhibit 1 is the scissor list, exhibit so and so is my signature. Material exhibit 1 is a pair of sandal and material exhibit 2 is the muffler. Thereafter, the accused person showed us the place where the dead body was buried. Exhibit 5 is a statement of Aizul Haq made before me. Exhibit 5.1 is the statement of Aizul in such terms. Later, I went with the police and showed them the place where the dead body was buried. Exhibit 6 is the statement of Habibur Rahman made before me. Exhibit 6.1 is the statement of Habibur Rahman in such terms. I laid the police and showed the place where the dead body was buried. Thereafter, I informed the magistrate. After the arrival of Ranbir Barada, magistrate and circle officer, Ding Circle, the dead body was exhumed as shown by the accused person, and later on inquest was held on the body of deceased. Exhibit 7 is the inquest report. Exhibit 7.1 is the signature of Ranbir Bora, the circle officer, which I am familiar with. I examined the witnesses. Later on, I sent the dead body for postmortem examination. I prepared a sketch map of the place where the dead body was recovered. Exhibit 8 is a sketch map and Exhibit 8.1 is my signature. I prepared a sketch map of that place also where cycles, sandals, etc. were recovered. Exhibit 9 is a said sketch map and Exhibit 9.1 is my signature. I brought both the two accused persons to the police station. Rumena Khatun lodged an Ezahar that day itself. On the basis of that Ezahar Dhing PS case number so and so was registered, the OC entrusted me with the investigation. Exhibit 2 is the FIR, exhibit so and so is the signature of the OC, Sushil Kumar Datta, which I am familiar with. Taking the charge of investigation, I questioned the complainant at the police station. I examined other witnesses also. I went searching for the other accused person involved in the case, but I could not find them out. I arrested accused Habibur Aizul Haq and forwarded him to the court. Thereafter, I was transferred. I handed over the case diary to the OC. Cross on behalf of the accused Habibur Rahman and all other accused persons. Sweeper exhumed the dead body at about 1:30 p.m. The Ezra was lost at about 3 p.m. that day. On the basis of the GD entry, I visited the place of occurrence. I did everything, that is going to Matikula Bazaar, taking the accused person into custody, preparing the sketch map at the embankment, seizing the items, exhuming the dead body, holding inquest on the dead body, and sending the dead body for the postmortem examination on the basis of GD entry. Your Lordship will kindly note this part. On the basis of GD entry, so this GD entry can be treated as a FIR, Your Lordship. I did not send accused Habibur and Aizul to court for getting their confessional statement recorded in connection with their confession and their assertion that they would be able to produce the dead body that day. I did not record statements of independent witnesses at that time when the accused person said that they would show the place where the dead body was buried. I had sent the dead body to the court for postmortem examination before I returned to police station. I did not see the bicycle in the court today, which was seized by the Exhibit 1. I did not seize that lamp in the gleam of which the wife of the deceased recognized the accused person. PW5 Afzal Hussain Khan did not state to me that Ajibu's dead body was recovered from the jute field at the other side of the dead channel of the river. PW6 Abul Qasim Farazi did not state to me that in the market, Rumena Khatun cried and said that her husband had not returned home. PW6 did not state to me that Qasim Master, he and many others came to village Romari and Aizul and Habibur came near the embankment. PW7 Iqbal Hussain Kabir did not state to me that when he was coming out from Masjid, Rumena cried and said before the public that in the previous night, Habibur and Aizul had called away her husband. PW7 did not state to me that after hearing Rumena, they went to the embankment and found shirt, a pair of sandals and a bicycle lying there, and that thereafter they went to the house of Habibur and Aizul, and having found them there, they brought them to the market. Rumena Khatun was present there at the time of recovery of the dead body at 2:50 p.m. We took the accused person to the police station. Thereafter, the accused persons were not taken to the place of occurrence. The time of preparing Exhibit 1 is not mentioned in it, but in the diary it is 9:20 a.m. I did not maintain any other memorandum except the case diary for investigation. I wrote the exhibit 6-1 after recovery. So Lordship made a query in this regard. I wrote the exhibit 6-1 after the recovery of the dead body. Though the case so and so is mentioned exhibit 1, but the case was not registered so and so. Regarding exhibit 6-1, may I submit your disclosure statement was made, which was exhibited as exhibit 6, not as 6-1. He put his signature, rightly said, my lord. 6-1 was made after preparation of the Lordship disclosure statement. That is his signature only, my lord. 6-1, 5-1 and 6-1. After the disclosure statement was made, your lordship, he put his signature. That's rightly done, my lord. Because exhibit 5 and 6 are the disclosure statements of the accused persons, Habibur and Ajizur, my lord. So there is no infirmity, your lordship. And this disclosure statement is admissible in evidence, and this accused person along with others can be convicted. Why I'm saying along with others, apart from Mia Hussain, my lord, because they had a conspiracy, my lord, in order to kill because of previous dispute with the victim, my lord. Regarding the place of residence of the accused person, that they are not the residents of village, my lord, Kandulimari. May I take your lordship to the charge sheet, my lord? Charge sheet at page 102. Here at page 103, my lord. Page 103. Here, the address of the accused persons are given as all are of number 2 Kandulimari PST. Lordship, so PW 1 and 2 had said they are the close relatives. They reside adjacent to the residence of the this one informant as well as the victim, my lord. But what happened, your lordship? He might have shifted his place to village Romari. So subsequent statements in 313, it was recorded as Romari. And your lordship, while the process server went to serve the summon as well as the warrant, he was not found. And in the report, it was said that he was not available, your lordship. They might have shifted his residence from village Kandulimari to village Romari by the time, your lordship. So it's a necessary corollary, your lordship, that can be drawn up, that the accused person shifted their residence from village Kandulimari to village Romari.
After the incident.
Yes. As a result of which the process server could not found them on the place of occurrence.
But then the Ijahar,
Yes,
Ijahar something,
my lord. My lord, which part, my lord?
the address,
Yes, it's written residence of Romari.
page 4.
Is for accused number 5, residence of Romari. Yes, yes, he is accused number 5, I think. Raised residence of number 2 Kandulimari. Yes, it's written. But your lordship, it's not their case that they don't know each other. They were cousins, close relatives. So in the light of lamp also, they will recognize them. So PW2 said, like, in the light of lamp, they have recognized the accused person. These 2 persons came to them, my lord, to pick up the victim. May I proceed? So in the case in Invader, on the basis of disclosure statement leading to discovery, last seen theory, and on the basis of extrajudicial confession, persons can be convicted, right, no? And can be roped in under section 302, 34, 201. So in this aspect, I refer certain judgments of this Honorable Supreme Court, my lord. 2009, 14 SCC 582. First, I'll satisfy your lordship on the point of GD entry, my GD entry. 2003 6 SCC 175.
2003.
6 SCC 175. Para 14, my lord. Para 14, 15, 16, 17, and 25. Superintendent of Police, CBI, and others, Mr. Tapan Kumar Singh. Para 14, your lordship. The crucial findings recorded by the High Court is that the facts stated in the GD entry did not disclose the commission of a cognizable offense, and consequently the police had no power or jurisdiction to investigate the allegation made therein. Thus, the investigation undertaken and the search and seizures made were illegal and without jurisdiction and deserve to be quashed. Para 15, it is the correctness of this finding which is assailed before us by the appellants. They contend that the information recorded in the GD entry does disclose the commission of a cognizable offense. They submitted it even if their contention that after recording the GD entry, only a preliminary inquiry was made is not accepted. They are still entitled to sustain the legality of the investigation on the basis that the GD entry may be treated as a first information report since it disclosed the commission of a cognizable offense. Then para 16, the parties before us did not dispute the legal position that a GD entry may be treated as a first information report in an appropriate case where it discloses the commission of a cognizable offense. If the contention of the appellants is upheld, the order of the High Court must be set aside because if there was in law a first information report disclosing the commission of a cognizable offense, the police had the power and jurisdiction to investigate, and in the process of investigation to conduct search and seizure. It is therefore not necessary for us to consider the authorities cited at the bar on the question of validity of the preliminary inquiry and the validity of the search and seizure. Then, your lordship, para 17. We have earlier in this judgment reported a GD entry dated 17/10/1990 is extensive. The facts stated therein are that the respondent was a corrupt official and was in the habit of accepting illegal gratification, that he had demanded and accepted cash to the tune of rupees 1 lakh approximately, and that he would be carrying with him the said amount while going to Nagpur by Gitanjali Express on 17/10/1990. Then para 25. Para 22 would also be relevant, your lordship. The High Court has also quashed the GD entry and the investigation on the ground that the information did not disclose all the ingredients of the offense as if the informant is obliged to reproduce the language of the section, which defines criminal misconduct. So, and so it would not be that relevant. But your lordship, the GD entry, because in our case, on the basis of the GD entry, all the investigation leading to discovery, then the seizure and all were made, your lordship. So that FIR which was filed subsequently, if your lordship takes into account the evidence of the IO, then that FIR can be treated as 161 statement. And this GD entry on the basis of with all the formalities, all the lordship, whatever has to be done is done, your lordship, but IO concerned, this GD entry may be treated as an FIR, your lordship. Then one more judgment, 2021 5 SSC 469.
2021.
5 SSC 469. Para 15.2. Need it, need it. The GD entry, whether I'll slowly read your lordship, only one para, 15.2. Even as held by this court in CBI versus Tapan Kumar Singh, a GD entry recording the information by the informant disclosing the commission of a cognizable offense can be treated as FIR in a given case, and the police has the power and jurisdiction to investigate the same. However, in an appropriate case, such as allegations of misconduct of corrupt practice by a public servant, before lodging the first information report and further conducting the investigation, if the preliminary inquiry is conducted to ascertain whether a cognizable offense is disclosed or not, no fault can be found. Even at the stage of registering the FIR, what is required to be considered is whether the information given discloses the commission of a cognizable offense, and the information so lodged must provide a basis for the police officer to suspect the commission of a cognizable offense. At this stage, it is enough if the police officer, on the basis of the information given, suspects the commission of a cognizable offense, and not that he must be convinced or satisfied that a cognizable offense has been committed. Despite the proposition of law laid down by this court in the Catanam decisions that the stage of lodging the first information report, the police officer need not be satisfied or convinced that a cognizable offense has been committed. Considering the observation made by this court in P. Sirajuddin and considering the observation by this court in Lalita Kumari before lodging the FIR, an inquiry is held and are conducted after following the procedure as per Maharashtra State Anti-Corruption and Prohibition Intelligence Bureau manual. It cannot be said that the same is illegal or police officer Anti-Corruption Bureau has no jurisdiction and authority nor power to conduct such an inquiry at pre-registering a FIR stage. Lordship, may I take your lordship to the Yanab Sheikh judgment referred by my learned advance regarding the GD entry part, my lord? Para 5, 6, 7, 8, 9, and 15, my lord. Agar case to DC में, agar case to Yanab Sheikh versus State of West Bengal. I think that's it already. Manupatra citation. 15. Yeah, criminal appeal number 905 2019 is given. You know, citations. No, it would be there. It would be there, my lord. Yes.
2013 6 SSC 428.
Para?
Para 5, 6, 7, 8, 9, and 15.
Okay.
Lordship, may I read it slowly, Your Lordship?
Yes.
Para 5. First and foremost, we may examine the question whether FIR exhibit so and so can be treated by the court as a first information report, and if so, what is the effect of exhibit 7 in law? Keeping in view the facts and circumstances of the present case, it is clearly established on record that the occurrence took place in the evening on 19 December 1984. The occurrence is a result of an altercation and the abuses heard at PW1 and the deceased by Yanab near the water tank. Immediately upon the altercation, the accused had ran to his house and returned along with Nazrul and threw a bomb at the deceased. PW1, brother of the deceased, PW5, Basira Bibi, wife of the deceased, and PW6, Abdul Sukur, cousin of the deceased, are the eyewitnesses, and they said that they had seen the appellant throwing a bomb upon the deceased and that the accused Yanab had taken the said bomb from the bag of Nazrul. After the incident, PW6 had gone to the Dunigram post office and informed the police about the incident over the telephone. He informed the police that there had been a murder in the village and they should come. When the police arrived, he was in the village and he met the police at the house of the deceased Samim. This phone call was taken and the GD entry was registered by PW14 SI RP Biswas. According to PW14, the 19 December 1984 at about 0805 hours, he had received a telephonic information and noted the information in general diary number so and so, and thereafter he had proceeded towards village Lauria along with PW15. SIS Chatterjee Exhibit 7 had been recorded by PW4 and he had received the written complaint by PW1, Sadek Ali, and the same was submitted to him after he had reached the village Lauria and was addressed to the officer in charge, Rampurat Police Station. This written complaint was Exhibit 1. The cumulative effect of the statements of PW1, PW6, and PW14 clearly indicates that Exhibit 7 was not the first information report of the incident. It gave no details of the commission of the first crime as to who had committed the crime and how the occurrence took place. A first information report normally should give the basic essentials in relation to the commission of a cognizable offense, upon which the investigating officer can immediately start an investigation in accordance with the provisions of Section 154. Chapter 12 of the Code. In fact, it was only upon reaching the village Lauria that PW14 got particulars of the incident and even the names of the persons who had committed the crime. A written complaint with such basic details was given by PW1 under this signature to the police officer who then made endorsement as Exhibit 11 and registered the FIR Exhibit so and so. In these circumstances, we are unable to accept the contention that Exhibit 7 was, in fact, in law, the first information report, and Exhibit 13 was a second FIR for the same incident occurrence, which was not permissible and was opposed to the provision of Section 162 Code. In the case of Manu Sharma versus State and City of Delhi, 2010 6 SCC 1, a bench of this court took the view that cryptic telephonic messages could not be treated as a FIR, as their object is only to get the police to the scene of offense and not to register the FIR. In our case, the informant is elaborately stated, the lordship, that the accused person, the victim was murdered, my lord. A murder has taken place. A cognizable crime has been taken place, my offense has been taken place. The same intention can also be clearly culled out from the bare reading of Section 154 of the Code, which states that the information, if given orally, should be reduced to writing, read over to the informant, signed by the informant, and a copy of the same be given to him, free of cost. Similar view was also expressed by a bench of this court in the case of State of Andhra versus V.V. Pandurang Rao. Lordship, then observations given. Certain facts have been rightly noted by the High Court, but the information is only one which required the police to move the place of occurrence, and as a matter of fact, the detailed statement was recorded after going to the place of occurrence. The state statement is to be treated as a FIR. but where, so Lordship will kindly note this part, where some cryptic or anonymous oral message which did not in terms clearly specify a cognizable offense cannot be treated as a FIR. The mere fact that the information was the first in point of time does not by itself float it with the character of FIR. The matter has to be considered in the background of section 154 and 162 of the Code of Criminal Procedure. A cryptic telephonic message of a cognizable offense received by the police agency would not constitute an FIR. Then your Lordship, para 9. Thus, the purpose of telephone call by PW6, when admittedly he gave no details leading to the recording of entry, would not constitute a first information report as contemplated under section 154 of the code. The reliance placed by the learned counsel appearing for the appellant upon the provision of 162 of the code is thus not well founded. Even in the case of Ravishwar, Manchi and others were state of so-and-so, 2008 16 SCC 561, another bench of this court took the view that we are not oblivious to the fact that a mere information received by a police officer without any details as regards the identity of the accused or the nature of the injuries caused to the victim, name of the culprits may not be treated as a FIR, but had the same been produced, the nature of the information received by the police officer would have been clear. On this principle of law, we have no hesitation in stating that the second FIR about the same occurrence between the same person and with similarity of scope of investigation cannot be registered by applying the test of similarity. It may then be hit by provisional so-and-so. So in our case, your Lordship, on the basis of GDNT, entire thing was done, your Lordship. Investigations almost completed, my lord. In the sense, whatever disclosure statement was recorded, police seized the articles, my lord. Dead body was exhumed. So, your Lordship, even if your Lordship do not take into account the FIR, this GD entry is, Lordship, sufficient to be considered as FIR, your Lordship. My lord. Then para 15, just one more paragraph, my lord. On the plain reading,
Yes.
on a plain construction of the language and scheme of section 154, 156, and 190 of the code, it cannot be construed or suggested that there can be more than one FIR about an occurrence. However, the opening words of section 154 suggest that every information relating to commission of a cognizable offense shall be reduced in writing by the officer in charge of a police station. This implies that there has to be the first information report about an incident which constitute a cognizable offense. The purpose of registering an FIR is to set the machinery of criminal investigation into motion, which culminates with filing of the police report in terms of section 172 of the code. It will thus be appropriate to follow the settled principle that there cannot be two FIRs registered for the same offense. However, where the incident is separate, offenses are similar or different, or even where the subsequent crime is of such magnitude that it does not fall within the ambit and scope of the FIR recorded first, then a second FIR could be registered. The most important aspect is to examine the inbuilt safeguards provided by the legislature in the very language of section 154 of the code.
Get someone to fix it up. We will come back after that. We will come back after 10 minutes. We'll get someone to fix this problem.
Yes.
We'll come back after. Yes. Oh, here also same problem. Oh.
Thank you, sir.
Then it cannot be. Lights are not.
Tamilda. Pure.
Yes, we want to finish out this matter, no?